Distinguished colleagues, can we be seated for the session? It's about to start. This session is the legal and constitutional rights and obligations of lawyers in public service in Nigeria. Please, if you are here for this session, please take a seat. There are a lot of seats up front, so those of you who are at the back, you can draw closer, because it will be difficult to, in case you have questions at the end of the presentations, you will not be seen if you are right at the back. To chair this session, I'd like to invite our past president of the Nigerian Bar Association, current chairman of the Council of Legal Education, the one we popularly call Juju Priest, our dear own OCJ Okocha, Senior Advocate of Nigeria. Please give him a round of applause. You're welcome, sir. The speakers for this session are as follows. We invite Sheyi Shoemimo, Senior Advocate of Nigeria. Please come to the high table. Ferdinand Obi, Senior Advocate of Nigeria. Please come to the high table. You're welcome, sir. Chukwuma Ekomaro, Senior Advocate of Nigeria. Please come to the high table, sir. Our own General Secretary of the Bar, Mazi Afam Osigwe, please come up to the high table. Abdul Karim Abubakar Kana, PhD. Please come to the high table, Dr. Kana. And last but not the least, Solomon Ibadan, Law Officers Association. Please come up to the high table. The focus of this session as the title indicates, is to discuss rights and obligations of lawyers in public service. Mr. Chairman, the panel having been constituted, I respectfully hand over the session to you for your guidance. Thank you.
Thank you, Mr. Elachi, Chairman Abuja Branch. You are not the session manager, so I have to thank you for coming to the rescue. A lot of people have been anxious to participate in this session, particularly our colleagues in public service. It is a very topical issue that will be examined at this session. And I have to thank all of you for your patience, and I will hope that we will have an enlightening and insightful presentation from all our panelists. I do not know why my learned brother Silk, from the class of 78, that famous class of the Nigerian Law School, is not here. I speak of Sheyi Showemimo, SAN, who is also the secretary of the Body of Senior Advocates of Nigeria. But I believe he will have sent somebody. Is there anybody here representing Sheyi Showemimo, SAN? This is the problem when you don't have session managers, because they should confirm all these before we actually start. But as we say in Port Harcourt, nothing spoiled. So my lords, ladies and gentlemen, I welcome you all. This is a parallel session that has been given full impetus. That is why we are using the largest hall in this International Conference Center complex for the session. There are listed 1, 2, 3, 4, 5, 6 speakers, and we have 2 hours allotted to us, 2 to 4 p.m. to start and conclude. Well, I will take my time from when I started. Time does not begin to run against you until you have been duly and properly served. The topic, as I say, is a very interesting one. Indeed, as my learned brother Sel Kobe and I were sitting down there, about 3 separate individuals came to talk about the rights and obligations of lawyers in public service. And public service, I want to say, runs across the gamut of the public service in Nigeria, including those who are law teachers in the academia. And one of those who came to speak to us is, in fact, a well-known academician. He's a professor. He's also known as a well-versed practitioner in arbitration and alternative dispute resolution. I'm sure they've all prepared their questions. So I believe, my distinguished panelists, that what you will have to say here will only be to introduce the presentations that you have been asked to make on the diverse topics on this matter. So I will give you each 10 minutes in the belief that more reactions will come from the audience, which may elicit from each of you some further examination or re-examination of the topic based on the perspectives from which those who will question you will make their interventions. So once again, my lords, ladies and gentlemen, welcome to the session. And I will actually start now by inviting the next published presenter since I have no indication that Sheisho Emimo SAN is here to make his presentation. So please welcome Ferdinand Obi, Senior Advocate of Nigeria. He's from the Benin branch.
Mr. Chairman, distinguished panelists, senior advocates of Nigeria here present. I'm sorry, I'm not very good at protocol. Maybe I should have said my lords, justices present here, senior advocates of Nigeria, distinguished colleagues, ladies and gentlemen. Let me thank the organizers of this conference for choosing me to speak on this very simple but complex topic. Simple, straightforward, but complex and controversial. The legal and constitutional rights and obligations of law officers. I'm sorry, my paper is not available because at the point of printing it, something came and wiped it off my computer. But God forbid that I should use that as an excuse for not giving you a paper this afternoon. We start with the definition of a lawyer. Who is a lawyer? I know we are all lawyers, but we still want to define it for the purpose of the topic. A lawyer is defined by the Cambridge Dictionary as, and I quote, someone whose job is to give advice to people about the law and speak for them in court. I want, for the purpose of this topic, to define a public officer as a government employee. I think that is generic enough to cover so many things. A public officer has been defined by the is defined in the 5th schedule to the Constitution of the Federal Republic of Nigeria as, quote, public officer means a person holding any of the offices specified in Part 2 of the schedule. Part 2 of the schedule highlighted a list of public officers in Nigeria, and they are as follows: Office of the President and Vice President, offices of the governors and deputy, the National Assembly, the State Houses of Assembly, the courts, offices of the Attorney General of the Federation and states, ministers of the federal government and states, the armed forces, the police force and other law enforcement agencies, and other offices of a public nature. But for the exigency of time, an expose of roles, duties, and obligations of law officers within the context above would have been substantiated in our discussion of this subject matter. I want to define a law officer in public service as one who represents the government or government department, protects the interest of government, and of course, anybody who is a lawyer and who has any connection with those offices that I had earlier listed as contained in the 5th schedule to the Constitution. In the case of Laiwola and the Queen, the court stated that with regard to a law officer, it is in his discretion to decide in the light of what the public interest requires. Now, there are certain things we cannot close our eyes to. having regard to current developments in the profession. Let's go to the issue of stamp and seal. It was not part of my paper, but I can tell you that not less than 100 lawyers have approached me in the last 48 hours that I must speak on it. Now, the NBA has come up with stamp and seal of different colors for those in the private practice and for lawyers or law officers in government. When this policy was enunciated, the first controversy was whether there is any legal backing for it at all. And it took time to convince our colleagues that if you look at the Section 10 of the Legal Practitioners Act, there is indeed a legal backing for stamp and seal. So I believe that that is no longer controversial. What is controversial is the different colors that have been introduced by the NBA. And I'm being asked, is it legal? Since we are all lawyers, please permit us to look at Section 10. Sorry. Section 10. Section 10(1). Because this is so topical, I would prefer to go straight to the law itself.
Mr. Obi.
Sorry.
Is it the Legal Practitioners Act? Or
no, sorry. Rules of Professional Conduct for Legal Practitioners.
Thank you.
Yes. 10(1). A lawyer acting in his capacity as a legal practitioner, legal officer, or advisor of any government department or ministry or any corporation shall not sign or file a legal document unless there is affixed on such document a seal and stamp approved by the NBA. That's why I said that there's legal backing for the introduction of stamp and seal. But in this section, you are not going to find any color of seal. But as lawyers, it says to be determined by the NBA. It can be argued that in coming up with the stamp and seal and giving different colors to lawyers in public service and those in private practice, that is a determination of the NBA. So I can argue that determined introduces an element of discretion to be exercised by the NBA in the implementation or execution of this section of the law. It can equally be argued that you cannot read into a provision that which it does not contain. That so long as there is no specification as to the colors, then if you are now putting different colors, you are in fact reading into that statute what it does not contain, and that there's no legal backing for the colors. But it can also be argued that when the law talks about legal practitioners, legal officer, or advisor of any government or governmental department or ministry, it has already categorized the different segments of legal practice, and that the introduction is in line with the categorization that is contained in that statute. All these are possible interpretations. But my own view is that as members of this honorable profession, we can always come together to arrive at a meeting point, because the issues are not as straightforward as they look. There's the added dimension to it that law teachers, as at now, are completely excluded. So there's no stamp and seal for our teachers in the law school. And I know that the DG almost always these days is a senior advocate of Nigeria, so he cannot file anything in his capacity as a lawyer because no provision has been made. But I know that they have approached the MBA, and the MBA in his wisdom has said that yes, we will provide stamp and seal for you, but again of a different color. So where do we place all this? Some have argued that it's discrimination, that the Constitution provides that there shall be no discrimination. But there's a dimension to it I didn't see before, which one senior advocate brought to my notice this afternoon. And it is this: the whole concept of stamp and seal, has it not become, will it not become academic and archaic if we introduce the e-filing system as being proposed now in our courts? How do you stamp and seal a document you are going to file online? And when that was brought to my attention, I just smiled. I said, yes, the law is dynamic. It's possible that as at the time these rules were made, nobody envisaged that at some point in time, we are going to enter into the era of e-filing. But we must sympathize with the MBA. We have a duty to protect our profession. I do know that, and if you do not protect your profession, you are in deep trouble. There are so many quack lawyers out there. All this is designed to check the quacks. But in checking the quacks, we must ensure that we do it within the confines of the law. Duties of law officers. A law officer is a legal practitioner who acts for the state. Before he can so act, the state must have sufficient interest in the subject matter that is being tackled. It is only then that the law officer can justify his appearance for and representation on behalf of the state. In Re Oshinlaja, government employee, see in Re Oshinlaja, citation supplied. Government employees are entitled to be represented by law officers depending on the subject matter. Indeed, a law officer may represent a private litigant where the court is satisfied that the government is sufficiently interested in the subject matter of litigation. I know that's slightly controversial, but that was a decision in the Queen versus Resident Ijebu province, so I am not the one saying so. The law officer owes the same duties to court as we have stated above, for like any other legal practitioner. He's an officer of the court. In addition, he owes certain duties arising from the peculiar nature of his function. In this wise, I usually say that I'm not envious of anybody who is a law officer in the public service. Why? Because sometimes you may have difficult superior officers who are not interested in what the law says. I know in situations you give advice, some members of the executive may just simply ignore it. The question is, what would you do under such circumstances? Some have advocated that if you give advice and it's not taken, you resign your appointment. But I know that that is easier said than done, because there are so many considerations. You cannot just say, I resign my appointment. But for political office holders in the category of, say, Attorney General, there's no reason.
2 minutes.
There's no reason why you cannot resign your appointment if you find that the governor or president you are working with is a difficult person and does not want to conform with the tenets of the rule of law. I will just quickly run through a few things. In the rules of professional conduct, some duties of law officers are highlighted. You can find these in Rule 37, 4 to 6. The primary duty of a lawyer engaged in public prosecution is not to convict, but to see that justice is done. A public prosecutor shall not institute or cause to be instituted a criminal charge if he knows or ought reasonably to know that the charges are not supported by probable evidence. A lawyer engaged in public prosecution shall not suppress facts or secret witnesses capable of establishing the innocence of the accused. We don't have problems with these, but where problems come is when, say, a governor directs you to go and enter nully in a murder charge, where from the proof of evidence you are pretty sure that that person committed the murder. It has happened in a few states, so it's not fiction. What do you do? My own recommendation is that in such instances, the Attorney General should just resign and stand on the path of the rule of law. We have also looked at Section 6 of the Legal Practitioners Act. And one thing I found interesting there is that it gives the right to sit in the inner bar to the Attorney General of the Federation, the Attorney General of any state, and Solicitor General of the Federation. I didn't see that status or that privilege being given to Solicitor Generals of the states. I think we should look at a possible amendment of that section. Well, I want to end this paper by recommending to us the German model and to tell you the importance that is attached to the teaching of law. So I believe that the MBA ought to move very quickly to address the issue of law teachers as far as stamp and seal is concerned. In Germany, you cannot teach law unless from time to time you have an opportunity to practice law for a continuous period of not less than 6 months. So you now find that there's an interface between those in the public service as law teachers and those who are practicing law in the courts. So every 6 months you will find that those in the classroom will move to go and practice, and those practicing will move into the classroom to teach. And why do they do so? If you don't do that, you will find that the teaching of law will become so theoretical that the lawyers you produce will not be able to function in the larger society, either as legal practitioners or to perform other functions as lawyers. So if that is the approach, and if that is the importance to which we place on teaching of law, there's no reason why we should not quickly address the grievance of law teachers as far as the stamp and seal concept is concerned. OCJ, when you give somebody 10 minutes to deliver a 30-page paper, you are likely to experience what you have just experienced now, because the man will be jumping from one corner of the paper to the other to cover the field. Thank you very much.
Thank you, Ferdinand. I can understand your predicaments. But don't worry, as I say, just make the main presentation. There will be an opportunity again for you after questions and interventions to further your presentation. Distinguished colleagues, my lords, the session managers are now here. Abdul Wasiu Alpha and Uju Okafor. You can now, I apologize, I heard they were already here when I was announcing that they were not here. But now that you are here, you can now take on your assignments. As I've directed, call the speakers down. If you have brief words of introduction concerning the speakers, you just give us as briefly as possible. We are constrained for time. Thank you.
Thank you very much. Yes, distinguished speakers, colleagues, we apologize for starting this session a bit late. It was not intended. We had been here, but there was a missing link somewhere. So we apologize sincerely. Yes, we are grateful to Chief Ferdinand Obi, SAN, and we'll be calling on the next speaker, Mr. Chukwuma Ekomaru, SAN, to take the podium. I'm grateful.
Yes. The chairman of session, our own OCJ Culture SAN, JP, may I sincerely thank the president of NBA, Chief Austin Alege, Senior Advocate of Nigeria, and the ABA Secretariat for giving me the platform to make my contribution to discussions on legal and constitutional rights and obligations of lawyers in public service in Nigeria. Law touches life at every point, from the time we are born and even after we die. At every point, law touches human existence. A lawyer has a critical role to play to ensure attainment of justice. The work of lawyers in public service, or what you may call government lawyers, is so critical and important that it's only the legal profession that you can find secured in the 1999 Constitution of the Federal Republic of Nigeria. No other profession was mentioned in the said 1999 Constitution. Section 150 of the 1999 Constitution of the Federal Republic of Nigeria provides in subsection 1 that there shall be an Attorney General of the Federation who shall be the Chief Law Officer of the Federation and a Minister of the Government of the Federation. Section 150, subsection 2 of the said Constitution provides a person shall not be qualified to hold or perform the functions of the office of the Attorney General of the Federation unless he is qualified to practice as a lawyer in Nigeria and he has so qualified for not less than 10 years. Gentlemen, the Attorney General is the Chief Law Officer. Any other lawyer you find working in any government department or government agency is a law officer. It is the body of lawyers that are described as the official bar. It is therefore my thesis that there is no difference in the professional and ethical privileges and obligations of lawyers in public service and lawyers in private practice. Whether you are employed by government or self-employed as a lawyer, you have the same ethical obligation and professional responsibility in rendering service to the public. Law is a service business. Our responsibilities as lawyers indeed center on our ethical obligations related to the services we provide to our clients, to profession, and to rule of law. As lawyers, we have a responsibility to provide services in the public interest and in furtherance of a safe, fair, and just society. Many of the lawyer's professional responsibilities are prescribed in the rules of professional conduct and in substantive and procedural law. You will notice in this conference that the MBA Secretariat gave a copy of the Rules of Professional Conduct 2007 to over 8,500 lawyers that are in attendance in this conference. Please, it's my humble suggestion that you read those rules like the Bible and the Quran. Don't say it does not concern you. If you read the rules of professional conduct, you'll be surprised that God has saved you over the years, because most of us unknowingly misconduct ourselves in the practice of our profession and indeed the way we live. A lawyer is a public citizen and should comport himself even in his personal affairs. A lawyer is also to be guided by personal conscience. A lawyer should strive to attain the highest level of skill to improve the law and the profession and to exemplify the legal profession's ideals of public service. Gentlemen, the business of law is about taking decisions. Government lawyers are on a daily basis taking decisions on matters of public interest. It is my humble and honest submission that if we are serious about fighting corruption in society, we must all collaborate to fight impunity and compromise. My humble view, and I say it with all sense of responsibility, if you walk into any government office and a law officer gives a legal opinion that is totally mad, please put on your garb as a human rights activist and scream blue mother to the MBA Secretariat. It is not only lawyers in private practice that are subjected to professional misconduct. Law officers are also to be subjected to queries on professional misconduct. This brings me most sincerely to the question of mischief and frivolity of some petitions. The MBA, is my humble suggestion, should raise sanctions for petitioners who file frivolous petitions just to witch hunt and undo lawyers. I have a very simple example in mind. A lawyer has worked very hard over the years to apply for the rank of Senior Advocate of Nigeria. A night to the final interview, a petition is instigated to stop him and pull him down. The person who writes such a wicked petition should not be allowed to walk away free. The MBA should contrive a relator action to proceed against frivolous petitioners. If we do not find a solution and consequence for frivolous petitions, we shall all, and I mean it, all of us, shall be endangered species in the practice of our profession. I noticed quite recently the judiciary have taken certain steps to arrest frivolous petitions by making sure that anybody who files a petition must take certain steps. It's my humble suggestion that since a lawyer, whether you're a law officer, you are a private practice, is a combatant, you have many enemies who would want to embark on frivolities. We should have some safeguard within the system to ensure that people are not put through unnecessary torment. I make all this statement because you will never understand what I'm talking about until one renegade writes a petition against you and you are subjected to a full-blown trial. In disciplinary trials, once a lawyer is charged before the Legal Practitioner Disciplinary Committee, there is a prima facie case against him. So he cannot make a no-case submission. It is my submission that all lawyers, whether in government service or private service, are advocates. Lawyers speak in favor, lawyers recommend, lawyers argue for a cause, lawyers plead for others. As advocates, we must always take sides. As Eli Wills stated in his acceptance speech as a Nobel laureate in 1986, he said, and I quote, "We must always take sides. Neutrality helps the oppressor, never the victim. Silence encourages the tormentor, never the tormented." According to my Lord Honorable Justice Ishak Bello, the Honorable Chief Judge of FCT Judiciary, in a paper his Lordship presented in 2004, he stated that the ideal bar advocacy must be rooted in the following: knowledge of the law. I pause to emphasize knowledge of the law. Most of the problems we have in our practice of law borders on the issue of knowledge. Yesterday we were having some kind of discourse, and we were saying a corrupt judge and a judge that is ignorant, which one is worse? They're all bad, but the one that is worse. I was talking to myself, and I was saying I think an ignorant judge is worse than a corrupt judge. Because a corrupt judge, as bad as he is, there are certain things he will not do. I'm sure he will not turn the law upside down. He will not. Yes. So the issue of knowledge of law, the issue of knowledge of law should be taken very seriously. Another good quality for anybody who is in practice of law is good and effective language, both spoken and written English. Skills in preparation and presentation of cases before the court, decorous behavior, honesty, continuing education, punctuality in courts. All these headings can run into several chapters and books. In conclusion, a lawyer performs various functions. As an advisor, a lawyer provides clients with an informed understanding of clients' rights and obligations and explains their practical implications. As an advocate, a lawyer zealously asserts the client's position under the rules of adversary system. Gentlemen, I would, in concluding, urge all of us to pay tribute. I sincerely pay tribute to Reverend Father George Ehusani, who gave a well-researched paper on the role of law in the promotion of justice and national development. The jurisprudence in that paper is a must-read for all lawyers, whether you are in public service or you are in private practice. You can reach me for a copy on my email because I already have a copy. That paper will prepare our minds to join the anti-corruption crusade of the present administration. I thank you for your time.
Thank you. Thank you, my learned brother Silk. But I'm sure the audience does not agree with you that an ignorant judge is better, or it's worse than a corrupt judge. The teaching is that an ignorant judge may learn, but a corrupt judge will continue to do damage to the system. Session managers, call the next speaker, please.
Thank you, Mr. Chairman. Distinguished senior advocates here present, my lords and confreres. Our next speaker, I believe, needs no introduction. But for the purpose of conference here, I would like to introduce the engine room of the NBA, Mr. Mazi Afam Osigwe, General Secretary, Nigerian Bar Association. Please give him a round of applause. Thank you, sir.
Chairman of session, co-panelists, distinguished colleagues. I'm glad this discussion is taking our conduct. Are we being discriminatory? Are we casting aspersions on our colleagues? Are we actuated by malice? The simple answer is no. Yes, it shows the audience is paying attention to me. If you look at that Rule 10, it categorizes legal practitioners. Legal practitioner, legal advisor, and legal officer, advisor, which also imposes a disability on public officers. It also shows that the law recognizes that even though we are all called to the bar, our names are on the roll, we cannot all do the same thing. In case there is any doubt that law teachers are public officers, as my friends will argue that they are not, I refer you to section 318 of the Constitution, which defines public officers, and it includes staffs of educational institutions owned by the government. And in case I am wrong, I refer you to the decision of the Supreme Court, Ahmed and Ahmed, where the Supreme Court confirmed that a law teacher in the employ of the Nigerian Law School, Kanu, was indeed a public officer. I think these issues are very simple. The question should be asked, why do I need to discriminate against my colleague? I absolutely have no reason. Some of them say, hey, you are afraid we take the briefs. And I said, why should I struggle for briefs with you? I'm not even sure I'll get the brief if it doesn't come to you. But why should you take the brief? You are salaried. Why don't you stick to it? To me, it's a simple argument. It's an issue of choice. When you have made a choice to take up an employment, it means you have waived your right to practice privately. No sentiments. I agree that law teachers need practical experience. But if the Constitution says they can't do that, should they? The motto of the NBA is the promotion of the rule of law. It is the duty of the NBA to regulate the practice of law, ensure that lawyers comply with the rule of law. And nobody should tell me that the Supreme Court said in Ahmed and Ahmed, oh, wait, it is for the code of conduct to convict them before you take any action. But I also draw the attention that the court did not make a pronouncement on whether a violation 2 of Rule 10 and Rule 8 cannot be challenged by the cannot be a ground for challenge without reference to Schedule 5. If we want to build a legal profession where people abide by the rules of professional conduct, where people do not eat from both sides, where people do not put themselves in positions of conflict of interest, we won't be having this argument. I'm sorry, but I'm going to speak frankly and bluntly. Some of us who are shouting no are people who are in public service, who, contrary to the code of professional conduct, maintain law offices, who sometimes divert briefs or government work to their private law firms, and they don't want us to stop them. Because if you don't have an ulterior motive, tell me what disability or what harm the red stamp does to you. It does nothing to you. Nothing. Absolutely nothing. Somebody asked a question this morning. The rule says I can do work gratis for my family members. Oh yes, you can. But I say, you do that with a red stamp, you put a jurat that you are a law officer, but you're doing this for your father and you have collected no fee. That should be a declaration. And you still do the work. It's not hurt you. And law teachers know that the order that allowed them to do private practice was repealed by Decree number 63 of 1999. Assuming it were not repealed, the constitutional provision also has stopped them, because that order, if it were still in force, would be inconsistent with the Constitution. What is the future of legal profession? What do you want to bequeath to our people? Is it a lawless place where legal practitioners behave as they want? That's not my idea of what we want to do. If the rules of professional conduct must have meaning, we must put our feet down and said, yes, this may well have been happening, but isn't it time it stopped? In his keynote address, the Chief Judge of Kenya made reference to a Nigerian proverb from my own part of the country, and he said, when a bad behavior lasts up to a year, it is being taken as a culture. This culture of impunity must stop. We are only enforcing what is in the rules. We are not making any new rules. We are not making any new rules. The indiscipline is getting out of hand. And we're undermining the integrity of the profession. Outsiders are watching. Foreigners do business in Nigeria. There should be clear-cut pattern of what a person can do or not do. The idea of the stamp is to show that if you have taken up an employment and we see a certain type of stamp, it becomes prima facie evidence that the wrong person is doing what that person ought not to do. It's not discriminatory.
2 minutes. 2 minutes.
Let us engage this. No emotions, no sentiments. I have no dog in this fight, but I have a dog in ensuring that we do the right thing. That I can hold my head high and say that I'm part of the MBA executive that says, let the right thing be done. Let's get it right. Thank you very much.
Thank you, Afam, as you were firing from all cylinders. I asked Ferdinand here, what of law lecturers in private universities? Are they being paid by government? They are affected.
Yes, law lecturers in private universities can't also because they're in salaried employment.
And the lawyer who is being paid a salary by a law firm, is he not in salaried employment?
That is the practice in a... No, I agree. They are in private practice. They are in private practice. So it's not that kind of employment that is envisaged by the law.
Thank you, my chairman.
My distinguished colleagues, these interventions by the chairman is to make the thing livelier, you know, because I'm constrained. As a former president, I cannot attack the regimes that have come after me directly. I can only advise. But maybe they know how my own mind is working. Thank you.
Thank you, my chairman. Able Sec. Mazi Afamosigwe. That was passionate, very passionate. We will help you to accomplish it because we are all involved. Okay, I'll be calling on the next speaker. That is Abdul Karim Abubakar Kana, National Association of Law Teachers, to take the podium.
Thank you. It's actually Nigerian Association of Law Teachers, not national, please. And in the last convention of the Nigerian Association of Law Teachers, Nado Ekiti, after listening to or reading the submission of Ms. Afamosugi, everything he just said here today, we resolved that teachers should not obtain and should not subscribe the red seal. We see that as a red card for us to engage in practice of law. The Nigerian Association of Law Teachers was founded in 1961 and is the umbrella body for all law teachers. And the idea behind establishing the body is to aid in promoting government policies and practices related to legal education and research. The association also helps in legal research, law reform, curriculum development, advancement, and pedagogical improvement in view of national and international developments. And we have continued to hold conferences every year. We have continued to use the body to protect the interests of teachers. I was elected as the president of NALT in June this year to succeed the outgoing president, Professor Smaranda Olarinde, the Dean of Law of Afi Wabalo University. Now, the challenge we have as teachers in view of the position of MBA with respect to entitlement of law teachers to practice law has been captured by the learned SN that it's absolutely impossible for teachers to achieve or to fulfill their responsibility of effectively teaching law without field experience. There are two types of law teachers. The ones who are drafted straight from law school into the classroom with absolutely zero experience in practice, and the ones who are engaged from practice, who have the true experience needed to impart and prepare the students for the challenge ahead. Now, getting those ones who are core and key to achieving the responsibility of teachers to agree to come to the classroom in most cases, and in my capacity as dean, and I can tell you I know, is if they will be allowed to keep their practice. Otherwise, they won't come. For the last few years, there has been a steady decline in quality of teaching, as may have been accepted, was evidenced last year. The bar exam last year, there was a massive failure. I'm happy that the chairman of the Council of Legal Education, as at last year, is present here, Elena S.A.N. Okocha, and he is the immediate past chairman of the Council of Legal Education. When the report came,
I'm still the chairman, eh? Don't retire me. I'm still the chairman.
Pardon, yes, yes. When the report came out that there was such massive failure, the questions was why? The MBA, members of the bar, and the general public, no one bothered to commission any form of study to confirm the exact cause of the problem. But conclusions were drawn. There was so much conjecture on the issue, and the conclusion was that it's the fault of teachers. I agreed, it's our fault. It's always the fault of teachers when things go wrong with respect to the quality of education. But then, what exactly is the reason why teachers are failing in fulfilling this obligation of preparing teachers for the task ahead? As there has been a steady decline in the quality of legal education, massive failures in the bar exams, there has also been a steady, and that's what many people do not understand, a steady decline in number of law teachers who are engaged in practice. Majority of law teachers today are drafted straight from the classrooms, from the law school into the classrooms, and they teach law. And then we prepare these kind of students who will go to law school with the new curriculum of law school, which emphasizes on practice. And that is just why they fail. But nobody bothered to look at it from that perspective. Before I go into the meat of my paper, really, I think I must make this appeal. I know teachers are the poorest people, and usually when they speak, very few people bother to listen to them, except, of course, if they are before them in the classroom. Of course, yesterday I tried to ask a lady out to marry her, and she said I'm a teacher, she wouldn't marry me. That's occurs all the time. But then it's also obvious that Mr. Alpha Mesugwe and his likes want to keep it that way, that law teachers remain poor. Because law teachers, as public officers, they remain the poorest categories of law officers today. Section 10 empowers MBA to issue the stamp and seal. There's no doubt about that. Sorry, of the rules of professional conduct. Rule 10 of rules of professional conduct empowers them to do that. And there's no doubt about that. The red seal, however, and the discrimination on the basis of seal is what we quarrel about, and we found that as discriminatory, and there's absolutely no basis for discrimination on the basis of colors. We see the debate initiated at this moment and at this time by Alpha Mesugwe as needless, and it's just unnecessarily starting a war where there shouldn't be any. We have resolved at the NALT conference that as much as possible we will fight any attempt to destroy legal education by stopping law teachers from practicing law. We have also resolved at NALT, at NALT, that any law teacher who compromises his responsibility of teaching on the platter of practice will be dealt with. And to that effect, we are taking steps. We have our own code of ethics, and we're also encouraging all institutions. But we believe that on matters of ethics, that should be left to institutions to handle. I must also start by saying that the topic that was handed over to me was the entitlement of law teachers to practice law, simple. But I paraphrased my paper to read, all teachers can practice and act as consultants for free or for a fee. And that is the title of my paper, and that aptly describes the conclusion of my work. I have tried to identify countries with superior and more senior legal systems than ours, and how they handled the situation. In the United States recently, I will read what one of the judges said. Sorry, it's a 25-page paper, because I was asked to submit the paper some weeks ago, and I thought they would have distributed the paper to everyone before now, but they decided to keep it in their systems. I don't know why. Because I think it would have been a lot easier for me and for every other person here to understand what I'm saying if everybody was holding the paper. And I also know that traditionally, in conferences like this, when papers are sent ahead of time, they are distributed to to the audience. But that is not done here. In the United States, the role of practice in legal education has been an issue for the Legal Academy since the Supreme Court Chief Justice Warren Badger publicly criticized law schools for failing to adequately prepare lawyers for practice. Several influential reports shifted the terrain of legal education towards a greater role of teaching of practice. Beginning with the Market House report, a commission was set up purposely to find out why there was a product of low-quality lawyers into the legal profession in the United States. And the findings was clear. There were no enough practicing teachers in the faculties of law, in the law schools of law. And the same also in Europe. In the Netherlands, law teaching is generally full-time, although private practice is permitted and common for many faculties and members. The position of Netherlands is the same with Germany, France, and most of the parts of Europe. I know Mr. Afam Osugue mentioned Germany and claimed that in Germany, teachers have the choice, or it's not a full-time job, but that's not true. I challenge him to bring out the authority where in Germany, teachers are not on full-time employment. The pedagogy of teaching law globally seems to be arriving at a consensus. The practice and practical teaching and learning, either by deploying experience of lecturer in teaching or clinical legal education and concept of experiential learning, is adopted as the best approach. This is so much unlike Nigeria, where the Bar Association has launched a rude assault on lecturers, instigating other lawyers to harass them whenever they appear in court. In Nigeria, there has been a decline in number of academic lawyers in the last 15 years, mainly due to contraction in the availability of viable briefs or fear of harassment by ignorant practitioners who, finding that they have no serious response to issues in the matter before them, embark on direct attack on law lecturer carrying out his legal duty on behalf of his client. As the number of academic lawyers decline, so also is the decline in standards of legal education. Now, the issue he raised with respect to those two provisions in the rules of professional conduct and the Constitution, I will address him on those issues. Paragraph 2 of the Code of Conduct. Let me start with rules of professional conduct. Rule 8.
2 minutes.
As a copy, please, sir. I couldn't have been asked to present a paper, made a 25-page paper, only to be made to make the presentation in 10 minutes. I know there's this saying that we should talk to our papers. Unfortunately for teachers, we talk to our students instead of talking to our papers. Rule 8 of Rules of Professional Conduct is also very clear. A lawyer, whilst a servant or in salaried employment of any kind, shall not appear as advocate in a court or judicial tribunal for his employer. For his employer, except where the lawyer is employed as legal officer in government department. A lawyer was, that's Rule 8.2. A lawyer was a servant in a salaried employment shall not prepare, sign, or frank pleadings, applications, instruments, agreements, contracts, deeds, letters, etc., for his employer. And all, it always ends with for his employer. In other words, this rule is ambiguous. It says for his employer. Does that mean that he could handle briefs of other persons other than his employer? So, paragraph 2 of the Code of Conduct for Public Officers, which he read, I have no dispute. I will not dispute with him on the content. Of course, I will just repeat for the purpose of clarity here. except where he is not employed in full-time basis, engage or participate in the management of or running of any private business, profession, or trade. But nothing in this subparagraph shall prevent the public officer engaging in farming. Fine. The question is whether the above provision limits the traditionally and globally known duties and responsibilities of lecturers in salaried employment, either in private or public institutions, by precluding the lecturers and all other teachers from engaging in research, collecting and collecting fees for it. Or it precludes us from offering consultancy services and collecting fees for it, publishing a book and selling it, undertakings as resource persons and collecting fees for it, engage as experts or scientists to carry out specialized research or discoveries for a fee while on permanent employment of a publicly owned institution. Does this rule prevent us? And if it does, it spells doom. That will mark not only the end of legal education in Nigeria, but the end of teaching profession in Nigeria. The day law teachers are prevented, the day this particular section is construed in a manner that prevents or stops law teachers from engaging in consultancy, or prevent law teachers from engaging in law practice. And I remember when I had cause to discuss this with the present GS and the immediate past GS, Emeka, and they asked me what's the difference between private practice and law practice. And I tried to clarify to them, private practice is what you do, law practice is what we do, and there's no law preventing us. Even the Constitution does not say that. I will not end my speech here this afternoon without acknowledging the presence of my two mentors, Professor Paul Idenege, SN designate is here, and Professor Maxwell Gidado, my immediate past Dean of Law, Nasarawa State University. I'm sorry, sir. I must acknowledge his presence because aside from handing over to me, making me probably one of the youngest deans of law in this country, and of course, consequently, the president of NALT, he mentored me into my fast rise in the profession.
Thank your professors.
I still have a lot to say on this. However, since I will still be given another opportunity to speak, I will beg to take my leave. I'm really grateful and thank you very much for listening.
Thank you. Thank you. President of NALS, law teachers, you've spoken also passionately, very, very passionately. The resource person should call the next speaker. Thank you. Please put your hands together for him.
Thank you. Thank you, Mr. Chairman.
There is an announcement that the Executive Secretary, our Executive Director, has asked me to make. There is a wallet here that has been picked, and it belongs to somebody who must have dropped it inadvertently. You will please, if you are the owner of this wallet, approach the Executive Director of the MBA, Mrs. Ifueko Alufohai, to identify yourself and collect it. Thank you.
It's on, sir. Sorry, before I invite the next speaker, I would like Mr. Chukuma Ekumaru to please avail our conferees of the email address he earlier on promised to give them in respect of the Reverend Father's presentation. Thank you, sir.
Gentlemen, the email address is Chukuma. That one is easy. It's Chukuma easy. CHUKWUMA. Ekomaru, that one is difficult. EKOMARU @yahoo.com. With that email, you get the paper of the Father Ehusin. Thank you.
Thank you very much. Ordinarily, I will have invited the last speaker to make his presentation. But I think I have the leave of the chairman of the session to kindly no, I will invite you before I invite you, sir.
The leave of what? Let it take.
Thank you very much. We have on the podium Mr. Solomon Idha.
That is Mr. Solomon Irado.
Thank you. Of the Law Association, Law Officers Association.
The President, Law Officers Association of Nigeria. I just ask you follow the order. We should learn to do justice and substantial justice at all times. The chairman of session, permit me to stand on the existing protocols. I have been invited to speak on the topic clarifying legal and constitutional rights and obligations of law officers in Nigeria. You would have noticed that the first speaker, our own, the learned Ferdinand Obi, SAN, and even the General Secretary of the Bar, Mazim Afam Osigwe, took time and extensively deviated from the topic of discussion and dwell extensively on the stamp and seal regime of the NBA. I have not come to bury Caesar. I have not come to praise Caesar, but to bury him. The issue is clear. If for a session that is designed and a topic is clarified, the General Secretary has taken it upon himself to assign a mandate. That is even in the first place a breach of protocol, it's a breach of mandate. Secondly, the implication is that there is a problem with the stamp and seal. I am made to understand that in the first session, in the morning, the whole session went about the issue of stamp and seal. We are here again this afternoon, and we are talking about stamp and seal. There is actually a problem. Now, I think at this stage, where do we go from here? The simple implication is issues has been joined. I'm happy the General Secretary of the Bar has come with all boldness and audacity to quote certain provisions of the law, the ROPC. At another instance, we hear of discretion. Since when has an organization, the issue of discretion, you talk about judicial discretion, you talk about administrative discretion. I don't know where the rules of professional conduct created a discretion for the NBA to go about distinction in the color of stamp and seal. We have actually resolved to maintain some level to say, yes, let's explore the option of dialogue. Now that the General Secretary has come to the open to declare that we are free to do what we want, I will seek the indulgence of the chairman of session that since issues has been joined, what is an aggrieved party expected to do? If we go to court, I'm sure nobody is going to go to the registry of the court to prevent the processes from being filed. But Mr. Chairman, I owe an obligation to my law officers to actually talk, even if it's for 5 minutes, the topic for which I have been invited, in line with my mandate. We do not envisage an end to this war, save victory. We are determined not only to win the war, but to win the peace. It is with a sense of honor and humility that I accept this invitation to speak at this breakout session. The topic is clarifying legal and constitutional rights and obligations of law officers in Nigeria. The theme for this year's conference, Annual General Conference of the Bar, is Lawyers and National Development. The question is, if the law officer is first and foremost a lawyer before being a law officer, it follows that your contribution to national development cannot be overemphasized. Now, we quickly go to define some terms because of time constraint. A law officer has been variously defined, no clear-cut definition as a matter of fact. But rights and obligations have been conferred, powers has been given. And that takes us to Section 150 of the 1999 Constitution, in respect to the creation of the office of the Attorney General of the Federation, and Section 195 of the 1999 Constitution, with respect to those of the states. I liken the provision of Section 150 to the book of Genesis, the book of creation. Because without Section 150 actually created the office of the Attorney General and other law officers, and that is why we have the capacity to stand and talk about law officers. The Law Officers Act defined law officer as every person appointed as Attorney General, Solicitor General, the Director of Public Prosecution of the Federation or of the state, shall, so long as he continue to hold such office, be deemed to be, and every person who shall have been appointed to any such office shall have been deemed to be a barrister, advocate, and solicitor of the Supreme Court of Nigeria. Flowing from the above definition, a law officer is a person appointed Attorney General, Solicitor General of the Federation of the State, Director of Public Prosecution, or a state legal draftman of the Federation of the State, or a state counsel, either in the Federal Ministry of Justice or other state ministries of justice. See Section 213 of the Legal Practitioners Act. However, pursuant to Section 3 of the Law Officers Act and Section 2(3) of the Legal Practitioners Act, a person cannot be a law officer without being called to the Nigerian bar. That is what distinguishes us from those who were referred to in FRON versus Osahon as those law officers in the public service. The functions and roles of the law officer is specifically designated in the Constitution in Section 150 and 195, and the subsequent section in Section 174, paragraph 1, 2, and 3. Section 211 in respect of the states, paragraph 1, 2, and 3. Legal and constitutional rights and obligations. In determining what constitutes the legal rights and obligations of law officer, I asked the question that filtered into the ears of a passerby senior lawyer. The question was, does the word duty and obligation have the same meaning? The lawyer was quick to answer, not the same. There is no doubt that the two words or terms have the same meaning or are interrelated. See, for example, power and right, duty and obligation. I have therefore taken the liberty to follow the line of thought of Lewis Carroll to use a word to mean what I choose it to mean. After all, when I see a bird that walks like a duck, swims like a duck, and quakes like a duck, I call that bird a duck. With this approach, I believe we can avoid the burden or the dilemma posed by the problem of definition by simply applying the words as they are used in the Constitution or the various statutes. The court in Fawemi versus Akilu, citation supply, was of the view that in the broad sense, power can be a right. Constitutional rights. The word rights legally means rights that are legally enforceable.
2 minutes, 2 minutes. You know your colleagues know all these definitions of rights.
Yes.
So go to the meat.
Go ahead, sir. If I have to, with all due respect.
2 minutes,
okay,
conclude.
sir. Now, legal duties is also defined as power to issue a fiat, power to issue nolle, then power to delegate. Now, legal rights, your entitlement, the difference between legal duties and legal rights is that legal rights are specified in the Constitution. Legal duties, constitutional rights are specified in the constitutions. Legal duties and obligations are creations of the Constitution. A law officer's legal duty is to ensure that justice is done. Atanda versus AG, Federation, AG, citation supplied. Raima JSC restated the position of the law. We have to remind prosecuting counsel that they ought not to look at themselves as advocates, but as ministers of justice, and their task is not to secure conviction, but to help in the administration of justice. We have a duty not to suppress facts. In Re-Achaji Upekun, the court strongly admonished a senior advocate and described his conduct as reprehensible for pressing upon court facts which he knows to be false. The prosecution counsel should not seek the position of maximum sentence. Legal and constitutional issues. The question they have asked is whether the powers of the Attorney General are personal to him. These are recurring issues. And the answer is simple, that the powers are personal to him. We talk about the rights that are created, the right to sit at the front row, the right to mention your case out of turn. The next query was whether the powers of the General to prosecute are exclusive.
Your time is up.
Yes, sir.
So
yes.
Please conclude now.
Yes, I round up with the Attorney, this is to the Attorney General of the various states and the Federal Attorney General, that as the Chief Law Officer, the Attorney General has a duty to properly advise government with legal audacity and boldness and lead by example by appearing before courts in the prosecution and defense of cases in which the laws of the states are called to question, rather than firming out these cases to few private legal practitioners at huge cost to government. In conclusion, I'm highly grateful to the President and members of the Planning Committee for finding me worthy to present this paper. Indeed, we are determined not only to win the war, but to win the peace. Thank you.
Thank you. Thank you, Ms. Ibadan. I'm sorry that I rushed you, because I knew that you had already started fighting the war, and you were determined to continue fighting, even in spite of my timekeeping. We will now go into interactive session. Earlier, the General Secretary had sought to make a reply on point of law, which I told him that he can save it until he has an opportunity. Is that Awakalo? Is that Awakalo there? Who is that tall man there? It's not, okay. So please, the procedure, moderators, is you identify those to speak, and those who are identified will come up, make their points after announcing their names and branches. And please, we don't want another lecture from the floor. No. The resource persons are the lecturers, they are the presenters, and when you have asked your questions, if you want to direct it to particular speakers, direct it to a particular speaker so that he will know and make notes. I will give them 5 minutes each at the end to round up. Thank you.
Very well. Would indicate. Yes, please indicate by raising up your hands. Yes, sir. Microphone, please. Mike, you can come on.
Please do not assume that your coming up means that you will give us another lecture. Professor Idonije.
Thank you, sir. I will not. I promise I will not. The chairman and the presenters, good afternoon, everybody. Paul Idonige is my name. I'm from the Abuja branch. I'll quickly refer to rules 9 and 10 of the RPC. Now, when you look at the Legal Practitioners Act and the RPC, there is no distinction between a law teacher and other lawyers. The LPA and the RPC refers to a legal practitioner. The issue is a law teacher a legal practitioner? Secondly, the qualification in rules 9 and 11 to practice law is to pay your practicing fee, which is mandatory for all lawyers. Pay your practicing fee, and in rule 11, attend your continuing legal education and earn your credits. These are the two requirements for practicing law. Now, the LJC has just made rules to allow legal practitioners in practice and in academics to be elevated to the bar. To the bench. On Sunday, at the opening ceremony, when the Honorable CJN referred to this, we all applauded. Now, why are we in a country where we seem to forget so soon that in this country we produce Professor T.O. Elias? In this country we produce Professor, let me come to them as justices. Justice Caribbean White. In this country we produce Justice Nikki Toby. And lately, in this country, we have produced Justice Mweze. These are renowned academics. Go and check the law reports. Go and see the judgment written by these renowned academics. Now, I ask the NBA, what does the NBA stand to lose if law teachers are in practice? Conversely, what does the profession gain if law teachers are involved in practice? My submission is, if we are to follow the position of the General Secretary of the Bar to the effect that all I can do is farming, I will regard that as infamous conduct in this profession, for which I should be disciplined. Now, if the GS is saying that they are not selective, the fifth schedule refers to public officers. Why is the MBA not referring to public officers? Why is the MBA singling out law teachers? I would have thought that if the intention is to protect the Constitution, what the MBA should go for is the prohibition imposed on all public officers, and not just the law teachers. For me, to focus on the law teachers is highly discriminatory, and I do not think it's necessary.
Thank you.
Thank you, sir. Thank you.
Thank you. Quickly, identify the next speaker.
Thank you, Mr. Chairman.
Okay, Dr. Benny, please come on.
Yes, it's okay. You can speak from there, Dr. Daudu.
I want to, by way of contribution,
Name and branch.
Benedicta Daudu from Jos is my name. I'm from Jos. Now, I want to add to the discourse by saying that the best of the law teacher is brought out when he or she is into practice. The essence of law school, the universities, is to students come out with very minimum practice. They only learn the theoretical aspect of law. However, when the law teacher goes to court and gets this experience, he's able to impart that experience to the students. And that is why students come out the better for it. When you take courses like criminal law, civil procedure, company law, and the rest of them, you discover that you can only get first-hand experience, impart this first-hand experience to the students when you have the benefit of the law practice. Law teachers pay practice fee. The best of senior advocates that we have, people like Efifani Azinge, Joash Amupiton, and the rest of them. It is because they are able to combine practice with teaching. And this has impacted positively on their students. So I want to add my voice to the fact that it is important, very imperative, that we allow law teachers to also practice for the benefit of the legal profession. When you talk about the poor performance of students, there are various factors that come to play. You do not look at the facilities in the library. You look at the environment in which they study. All of those are parts of the things that contribute to poor performance, but not the legal, not the lecturers. The lecturers, in spite of this poor condition, put in their best to ensure that students come out and perform very well in the society. Thank you.
Distinguished colleagues, I'm now under serious constraints. I've seen the distinguished chairman of the next session in this hall. The past chairman of the Body of Ventures has taken her seat. I think that is notice to me that I should begin to wind down. But Mrs. Balogun, with respect to you, we started late, so we will creep small into your own time. And I'm sure you also want to participate in this session. Hey. I hear you, madam.
And you know, we have another function later. We've not been back to our hotel. We're just hanging around here.
I understand, but we'll crave your indulgence. Just a few minutes.
I will appeal to you to kindly round up as a good chairman. And,
thank you. Well, I'm a man under orders. But Dele, please try and pacify our distinguished past chairman of the Body of Ventures. Carry on, Mrs. Uju. Call the next speaker quickly, so that we can round up. We'll take 2 or 3 more.
OCJ,
I'm ready.
Please, let's do it like this. It's about 10 minutes to 4.
Yes.
Please, on the dot of 4, you know we've got to get set. We can't even start at 4. We're supposed to start at 4.
I hear
so
you,
please, 10 minutes, wind up. Oh, yeah. Otherwise, I'm going. I want you.
Thank you, man.
Yes.
Mr. Chairman of
Chairman, what do I do?
Yes, next.
Yes.
Quickly, just one minute, gentlemen.
Yes, Chairman of this.
Ask questions.
Yes.
Save the comments. Ask questions if you have direct questions
No,
to ask.
I have a comment, Mr. Chairman.
Okay, 1 minute, please.
My name is Okeya Kobundu Jos Branch. Mr. Chairman, I want to make a distinction between a law teacher in practice and a lawyer that teaches law. What we're saying is simply this. I know that we should check the mischief that MBA has come to solve in this process, what we're talking about. I am a law student now. That's what I'm doing in school. Mr. Chairman, we all hear very clearly. Let us take it very clearly because our children are the ones who are suffering in the hands of these law teachers who choose to go to court. I have made the point several times where I'm at. A law teacher fixes a lecture for 9 a.m. on a particular day. The night before, he gets a hearing notice to attend a court session that is as low as even a magistrate court where he doesn't need to go there. I am saying this. He sacrifices the welfare and the education of students and goes to court. If you want us to do this, sorry please, Mr. Chair, let me end by saying this. What we are meant to learn in universities undergraduate is the substantive law. It is not procedural law. Let them go and do the research, read the law reports, and teach our students. They have no business in the law courts. Thank you very much.
Yes,
Mr. Chairman.
Just two more, please, so that we don't offend the next.
Silas Joseph Onu is my name.
Yes.
I'm the publicity secretary of Abuja branch. I just like to add to what he said. Considering the fact that the law teachers are Nigerians and should be subject to the Constitution, should the NBA disrespect and disregard constitutional provisions simply to please law teachers? And then secondly, I think that the decision of the law teachers not to respect a body as NBA is in itself an act of indiscipline. The law teachers cannot, as a body, decide to disrespect the Nigerian Bar Association. If they have an issue, they should go to the National Assembly, have the Constitution amended, instead of coming to a gathering like this to attack a policy or a project that is meant to protect the profession. Just like my colleague here said, the law teachers are self-centered. They just want to make money, not teach. Practicing
Don't make those accusations anymore. Thank you.
Practicing is taxing, just as teaching. You need to do research to teach. You also need to do research to practice. If you want to do both, which will you do better?
Thank you.
That is my question.
And we'll take the last intervention.
Okay, Mr. Chairman, sir.
One more, yes.
Yes, Mr. Chairman, sir. May I observe other protocols? My name is Cordelia Ake. I am from Port Harcourt branch. I'm a law officer. I'm quite passionate about this matter because, first of all, I was at the NEC meeting, the UNEC meeting, which the NBA says is the basis. That's what gave them the approval to go ahead with the different colors. I was at that NEC meeting, and I know the NEC meeting never approved the distinction in the colors that the NBA GS is talking about. Then I want to say something else. I think the NBA is looking at this, NBA leadership is looking at this from a very narrow point of view. Very narrow, because the issue of stamp and seal affects every sector of government. Now they are talking of lawyers in government. You have lawyers in the Ministry of Justice. You have lawyers in the National Assembly. You have lawyers, EFCC, the police, all of them. There are lawyers there. They want the government to buy stamps to file these matters. Last week, we went to file an action that was to challenge this stamp. And at the Abuja High Court here, they told us the action could not be filed because it does not have the NBA stamp. So already the judiciary has been dragged into this when issues are not yet resolved. We can no longer find matters to even challenge the NBA stamp. So first of all, we are denied at the registry filing matters. So if the registry has already pronounced the document irregular, then what is the court supposed to do? That is one. So now has the NBA, even the police could not file charges. They can't file. EFCC, they will all have to go and buy stamps. Has the NBA considered the effect of all this before they carry on with the stamp project? I think the NBA is supposed to, should consult. It should consult the stakeholders. I was there when my Solicitor General called the NBA president and said, you are talking about discipline of law officers. There are rules, and we are ready to work with you. There are rules of professional conduct. The civil service, the public service has its rules. I do remember that the former NBA president, who is chairman of this session, I know that when he was president, there was actually a notice that was issued by him concerning practice of the profession by lawyers that are in salaried employment. There was a committee set up for that purpose. Why is that committee not working? If you find lawyers that are actually contravening the RPC, take them to the disciplinary committee. NBA is not doing that. Lawyers in public service, you can also be in disciplinary committee. So I think this is actuated by malice. Purely malice. And NBA should be sincere to us. NBA should answer questions. NBA should resolve outstanding issues before it goes ahead with this project. Thank you.
Thank you, Mrs. Eke. Cornelia, I know you are very passionate. You will join Ibadan in the battle to win the war. This is where we will cap it so that we don't eat into any part of the time. But as you have observed, 3 are against. The General Secretary is the one who is for. Mr. Obe, my learned brother Silk, is for everybody.
Yes.
We are all right. MBA is right. Antagonists are right. So I will invite the General Secretary to take 2 minutes and respond to the very, very strong points made by those who are against. Thank you.
Thank you. Let me just say that Mrs. Cordelia Eke is wrong. If she was in Uyo, she would have known that NEC approved the presentation made by Strataflex, where it was stated that there are 2 colors of stamp, so she's not right. Now, Abdulkana, the chairman of NAUT, indeed is my callmate at the law school. So even though he tried to personalize it, I don't hold him responsible. And Professor Donije is my teacher. I saw a cartoon so many years ago in Newsweek that says, of a picture of a man beheading another, and said, this will hurt you as much as it hurts me. It's not personal. Rule 8 as interpreted by Abdulkana is wrong. It actually just says that a legal officer shall not do certain things for his employer. It's a taking that when you've taken one kind of employment, the other one is excluded. So the interpretation he has given it is wrong. And Professor Donije interpreting Rule 9 and 11 is also not losing sight of the other rules. Those rules merely said the minimum things you will do. It doesn't say once you do that, you can go dancing in the court. That's not the intention of those rules. You have to read the entire gamut of the rule and take it contextually. Now, the MBA, he said law teachers, sorry, say what does the MBA have to lose? It's not about losing. It's about what does the law say. Let us first agree that the law does not permit law teachers to do this. And they will say, going forward, what do we do? And let me say this, we are not singling out law teachers. We have written to EFCC, as Mrs. Eke would like to know, ICPC, Attorney General, say, look, you have to do this. Otherwise, these are the consequences. I understand if people want to go to court, but we are talking about enforcing a statutory provision. Let's cross the bridge and then talk about it. It is the law teachers that are making it an issue by constantly engaging the MBA. I was to have a meeting with Abdulkana, and he excused himself that he was coming back and never came back. It is the law teachers that are making it look as if anybody is particularly after them, together with the law officers. It's about everybody. It's about enforcing the rules, the rule of law. If the present government and everybody is saying change, due process of law, we should be seen to be at the forefront of it. We should not be seen to be emotional. My take is very simple. If law teachers want to teach, they should be willing to renegotiate their terms of engagement with the employers. Do you want to be a consultant? Do you want to have a non-tenured employment so that you will be able to continue? You cannot eat your cake and have it. You can't be in full salaried employment and insist on practicing. Professor Donije contradicted himself when, after saying that Rule 9 and 11 did not differentiate, talked about a rule made by the Chief Justice of Nigeria about appointing lawyers in private practice and academics. You've already accepted the dichotomy. Need I say more? The issue is simple. We are doing what the law says. It's not personal. We keep engaging all our members. It's not any intention to publish everybody. It is for the best interest of the profession. And for the law teachers who argue so much about practical experience, the argument can also be made that the law school result is a clear example as to why law teachers should face the class and teach students. Because the point can be made that when you leave your students to go and practice, they suffer, you don't teach them. When you come back, you don't have adequate time for them. That the knowledge you're actually gathering is to line your pockets and make more money, not to teach the students. That point can also be made. Thank you so very much.
Thank you. Thank you. Thank you. Distinguished colleagues, this brings to an end this first breakout session for the afternoon. Now, as the chairman, if you remember, there was a judge who told us a joke in our Port Harcourt branch. Counsel for the defendant delivered his address. The judge says, you know, you are very correct. The next day, counsel for the defendant delivered his own address. The judge said, you know, you are very correct. The judge went into chambers. The clerk asked him, my lord, plaintiff counsel, correct. Defendant counsel, correct. How are you going to judge this case? You know what the judge says? You know, my dear clerk, you are very correct. So the moral of this story is that everybody has a very, very strong and correct point. I think that the MBA needs to take a second look at this stamp and seal matter. Thank you. I thank all the speakers for their presentations, and I ask the resource persons to make one or two announcements before we yield to Mrs. Hirat Balogun's session. Thank you. Thank you.
Yes, distinguished members and conferees, be informed that there will be a golf tournament tomorrow at the IBB Golf Center at by 7 a.m. Equally also, somebody lost a wallet containing some of these items: NBA ID card, CAC ID card, national driver's license.
I think they've collected that wallet. Another one.
Another one.
Oh, I'm sorry.
6,000 passports. Please, if found, return to the secretariat. Thank you.
Please, let's clap again for OCJ Okosha for keeping to time. Please, let's get settled. We are going to another session, which I think is one of the most important sessions at this conference. The next session is uplifting ethical standards in the legal profession. And I'd like all the speakers for this section to please come up to this side of the table. Yusuf Ali, SAN, Odein Ajumogobia, Senior Advocate of Nigeria, Oladejo Lamikoron, SAN, Fubara Anga, Senior Advocate of Nigeria, Patrick Ediale, Past Chairman, Abuja Branch, Alex Moka, Past Chairman, Lagos Branch. Please leave the podium if you are not part of this session, please. Please. Please, the current section is uplifting ethical standards in the legal profession. Yes. Gentlemen, please, can we have some quiet? Please sit down. Prior to the establishment of the Nigerian Law School in 1962, the training of lawyers was done mainly in the United Kingdom. Mr. Idale, please come to the high table, please. In order to become a legal practitioner in Nigeria, one had to be called either to the English bar or Irish bar or enrolled as a solicitor in any of these countries. By Order 15 of 1876, the Supreme Court Civil Procedure Rules, the Chief Justice of the Federation was empowered
to admit to practice any person who satisfies him that is entitled to practice as a barrister or solicitor in England, Scotland, Ireland, and that he is of good character. Based on the above procedure to practice law in Nigeria, the first partnership that was established in Nigeria was established by 3 lawyers. And these were the law firm of Bode Thomas Esquire, F.R.A. Williams, and Chief Remi Fani Kayode law firm. And it was called Thomas Williams and Kayode. And this law firm was in Jankara Street in Lagos. So when you hear Jankara practice, you can know the origin today. The first set of students to enroll to the Nigerian Law School stayed for 3 months. That's January to March in 1993 at 2138 Igbosere, Lagos. However, the official commissioning of the 6-story building was during the second set of students in April to June in 1963. In 1997, the federal government moved the law school to Abuja, and the pioneering students of Nigerian Law School, when it started in 1962, were Masters S.A. Ajura, I.A. Idiamebi, S.O. Chuke, J.S. Ayaun, N.N. Onua, N.N. Wanchuku, O.C. Obi, and I.O. Sonoiki. Today, the legal profession in Nigeria has well over 100,000 lawyers and called to the Nigerian bar. And the umbrella body of Nigerian lawyer. Nigerian Bar Association has 111 branches spread over the length and breadth of Nigeria. Today, while welcoming you to the 255th Annual General Conference, we have deliberately chose our speakers because each of them personifies what we want to see in our profession in terms of ethics and compliance with the rules of professional conduct. I would want to again just briefly introduce them so that before I introduce our special chairperson for today's section. One of our speakers here is Yusuf Ali, Senior Advocate of Nigeria. Please, could you give him a round of applause, please? He's of Gallup Chambers. Odeyi Ajumogobia, Senior Advocate of Nigeria. Ajumogobia Okeke, past Minister of Petroleum Resources. Sorry, Foreign Affairs, Minister of State Petroleum Resources. I'm sorry, sir. Fubara Anga, ALS Legal Practitioners and Arbitrators. Please, let's clap for them, please. Oladejo Laimi Karan, Senior Advocate of Nigeria. It's of Oladejo, it's of Creeks, Sheets and Solicitors. Patrick Ediale of Patrick Ediale and Co. Alex Moka, past chairman, Lagos branch. Ladies and gentlemen, today we have carefully chosen a chairperson. I will say personally, my knowledge of this person is that I experienced one day a very young lady wore miniskirt to Lagos High Court. And our chairperson looked at the lady in horror and actually said, just open it and let's see everything. So if you are dressing to court and by mistake you run to this our chairperson, please go back and dress properly. So today we've carefully chosen her because she personifies ethics. She's been a past chairperson of the body of bencher, a life bencher, a past general secretary. Ladies and gentlemen, I present to you our chairman for this session, Mrs. Hairat Balogun. Please. Chairman, I hand over to you, sir, for directions.
Thank you very much, dear coordinator, I will call you. Please, let us be very time conscious. Each speaker shall have 8 minutes. 8 minutes. And there is no need for any repetition because we want the rest of us to have plenty of time to interact. Having said that, my learned friends, distinguished speakers, it's my privilege to call the session to order. I'll just make a few brief remarks, and I'll also ask 3 questions around which I hope the speakers will relate their talk. First comment I want to make, I hope all of us have a copy of the Rules of Professional Conduct for Legal Practitioners 2007. Do we all have one? Or have we all seen one? Please, this is our Bible. Whether you read the ordinary, I'm not even going to say ordinary, whether you read the Holy Bible or you read the Holy Quran, for the legal profession, this is our Bible. And if you refer to it, there is no way you will run foul of the ethics. I've also summarized the rules of ethics in my own language, which I will read out to you. The rules of ethics concern the following: to give correct and honest legal advice, to ensure that our advice does not lead our clients to a worse position than when he first briefs us, to show courtesy to our juniors and seniors as the occasion demands, and shun offensive language. Offensive language includes ordinary street language. As a lawyer, we must have a bit of decorum. We have our own ways of doing things, some way that stands us out from the rest of the society and for which they admire us. I'm sure many of us here know that silently the society actually envies every lawyer. Number 4, to be courteous to the bench and assist the judge to come to a reasonable just decision by the presentation of our arguments and case law. To treat witnesses with courtesy. There are easy ways of asking questions without embarrassing or harassing a witness, whether it's a claimant or a respondent. All that means is that you have to master the English language, because that is our language. The language of the court is English, so you have to master it in such a way that even when you are asking a question which a layman might find embarrassing or odious, you ask it in such an innocent, ordinary way, the person does not even know that you are putting them down. So you have to study your language very closely. You have to believe in the case of your client without stepping into the case, without stepping into his shoes and becoming belligerent or loud. Don't say, oh, they briefed you to do this case, so you too must get very pugilistic. It's not, the court is not a boxing ring. And that's why we have this ethic, that if your opponent is speaking, you only have to show that you want to object. You don't keep bantering with each other. You do not argue with each other, because you are lowering the integrity of the court. You give some time. The court will observe and say, your learned friend wants to make an objection, please sit down, let him resume his seat. So don't have two people standing up at the same time and everybody is just talking. You have to be properly attired without attracting unnecessary attention to yourself. You have to look neat and tidy. It doesn't mean you don't have to, you cannot be fashion conscious, but how would you feel? You go into a courtroom, you're sitting down, the ladies have exposed their thighs, and a man comes in, slaps you on the thighs, and you are angry. I've done it so many times. I see people with the shortest skirt available, and everything is exposed, so I slap them. And they look at me in horror and say, why, excuse me? I said, you excuse me. Isn't that what you wanted? Why are you assaulting my eyes? So, please, when we are out, you try to dress for the occasion. After all, when you are going to a wedding, you don't put on a tennis skirt, you don't put on trousers and plimsolls, you don't put on your gym attire. You put on a nice pretty dress or national dress. So why, for your work, can you not attire properly as you should? And I tell people also, we are in a uniform service, if you like. Our attire is like a uniform. You have to keep your uniform so people recognize you as an officer of the law, an officer of the court. Then you always try to exhibit a high sense of moral standard and integrity. Whoever you are, whatever you do, you must always preserve this sense of integrity. When people see you, that one will brook no nonsense. If you are hurting so much in your private life and you cannot go to court, you cannot defend your client, please stay away. You cannot be in two places at once. You cannot be at home and be at work. So you take an excuse. You can stand up in the middle of the court and suddenly feel you can't carry on. May I be excused? Any problem? I'm not feeling well. There is nothing a judge can do. And heavens are not going to fall. This is my favorite remarks. Heavens will not fall because you cannot make it fall. And the heavens that was made there will never fall. That's why God kept it there. So please, just consider, keep calm, and do what you should do. As I said, they look on us as if we're little gods. We can make anything possible. So because of this, we have to be calm and always have at the back of our minds the ethics of the profession. Finally, a lawyer shall not encourage a non-lawyer in the practice of law. A lawyer shall not encourage a non-lawyer in the practice of law. We're in the habit of saying, oh, let me help this man, he's my friend. Think of what you had to go through to get your certificates. And that is why I'm not doing commercial here. That's why, at least I think the Bar Association is trying to do something with this seal. They're trying to put some regularity into our daily affairs so that any fool can't just come in and pretend to be lawyers and then we're encouraging them because we think our rules are too strict. So having said that, the three questions or three areas that I want us to examine. The first one, let us, like the heading of the session says, uplifting ethical standards in the legal profession. Let us list the areas of falling standards, those areas that we think things are really getting bad. Let's list them. We can list them in our heads, but the speakers, I would like them to try and show us. 2, let's examine the reasons of falling standards. Most things nowadays, they say, oh, it's because the economy is bad, this one is, but there are some people who don't earn as much as we do. You may say, oh, we make more effort. They don't earn as much as we do. They still live respectably. Look at teachers. I'm not holding anybody's brief here, but obviously those teachers cannot be doing so well if they won't stay in the classroom. I heard some people complaining here a few minutes ago. They are supposed to be in the classrooms. What brings them out to practice? And my objection against those people, apart from breach of ethics, is that you got your status. Some of them have become SAN. They've got their status actually through teaching. It's the teaching that has honed their skills. So they should put back into that teaching what they have, at least part of what they've got. So they don't need to be rushing around to court to the detriment of their students. The third one, how can we make the rules of ethics more functional? We don't want to just keep them in the book. How do we make them more functional? Is it that we have to remind ourselves from time to time? I've met some very senior lawyers, and I say, oh, I'm annoyed with you. They say, why? I said, I came out of court just now. Somebody was behaving badly, and I'm tired of telling people, don't do this, don't do that. I'm not a mama nurse. I'm not. I'm just myself. I'm a practitioner like them. So I said, by the way, how many people have you corrected or assisted this week? I asked one particular senior that question. He turns to me and says, correct, assist. I don't want anybody to abuse me. I said, why would they abuse you? So, you know, some of these people, you try and correct them, they will start telling you, mind your own business. I said, oh, that is, I will tell them, this is my business. This is not the market. I am not a butcher, and neither are you. We're both lawyers. It's my business. I'm going to tell you. And what I usually do, if I try to correct you and you don't answer, you've forgotten. Next time, say, good morning, ma. I just say, excuse me, please do not speak to me. I can't speak to you because you are not worthy of being called a lawyer. Then they'll say, oh, this woman, she's horrible, she's terrible. But think on it. I've seen so many things. It's not a question of boasting, but sometimes when I tell people, please don't do that. I came to the bar on the dot of 21. Nobody, I'm just watching my seniors. Nobody ever told me, do it like this, do it like, I was just watching them and trying to imbibe. And I had the pride of saying, I know everybody who is my senior. I know everybody who is my junior at that time. And of course, I know my classmates. But I know we're many now. We cannot know everybody. But at least, you know, if somebody approaches you, you can size the person up. If you say, oh, my learner senior, the person will correct you and say, no, you know, I came out of Ife just a year after you. You laugh about it. That is how it should be. Finally, I want to say it's time that we become our brother's keepers. So I hope by the time the distinguished speakers have spoken to us, we'll all leave here a little bit richer, knowing exactly how we are to proceed. On that note, the right hand wins, right? Then I call him first. Can I? So, Yusuf Ali, please. 8 minutes.
The chair, I pay all compliments. My colleagues, good evening. Out of my 8 minutes, I'll take 1 minute to 30 seconds to do something. Please, I want to appeal to the organizers in future. When you invite us to come and talk, indicate the time limitations that we are going to go through. Because I prepared a paper of 20-something pages. Of course, I knew since I came on Monday that we are going to go through this. And I'm lucky I can present this in 5 minutes, actually. But the point is, don't put people through all this labor, only for them to come, and then you embarrass a lot of people who are not used to talking to their papers. So this is very important.
Learned essay, and I have to intervene. When you prepare your brief for the Court of Appeal and the Supreme Court, it can run into several pages. And you know the rule. You only allow 15 minutes. So you are used to it. You are used to summarizing. Help us.
Now there is, the paper is there on the screen. What I've tried to do, the lady's thing is not working. No. Come.
You can do it from here.
No, I would like to stand up, ma.
Oh, but this is not court. We are all friends.
Yes, I know.
We're learned friends.
It's okay. Now, what I did was I did an intro, and then I went into the issue of, actually most of the things I had in my paper had already been stated by the chairperson in terms of what we should do, what we should not do, and our duties to other lawyers, duties to the court. I quoted in extenso some of the provisions of the RPC. I made allusions to the duties to clients, our fiduciary obligations to clients, our relationship inter se between ourselves as lawyers, and I identified 4 main heads for which lawyers could be in trouble if you breach the RPC. Infamous conduct in a professional respect is one of it. I quickly ran conviction by any court in Nigeria having power to award imprisonment for an offense which is incompatible with the status of a legal practitioner. If you are convicted for stealing, for example, nobody needs to report you before action will be taken against you, because that is incompatible. A thief is incompatible with our status. Then obtaining enrollment by fraud, if at any point it was discovered. And I want to call attention to this innovation by the body of benchers. Either the benchers form had no space for commissioner for oath. This is now in the form, and I took opportunity to explain to all law students who came to me to sign their forms that the implication of this is that if any of the information you supplied in this form is found tomorrow at any point to be false, then you will be liable for the offense of perjury, because it's a sworn form, not ordinary form like before. Then lastly, conduct incompatible with the status of legal practitioners. Habitual drunkenness, using foul language in the public, and brawling. And I learned that yesterday some of our colleagues almost had it, practicing their acts of karate and kung fu here. If such persons are brought, if proper investigations are done and they are brought to LPDC, they could be in some... I set out the disciplinary procedure. Many of us do not know that the LPDC is not an arm of the NBA. The LPDC is part of the body set up by the body of benchers. And that was informed by what happened in the Ganifa against NBA case in the early 80s. The NBA now does only investigation of all allegations of misconduct against lawyers, and having done their part, the documents will be sent to if there is a prima facie case made, those documents will be sent to the LPDC secretary, and then from there, it comes before the LPDC. I highlighted some of the challenges facing our practice, which is also impacting negatively on discipline. One of it is the incursion or encroachment of other professionals in our profession. Those who practice with accountants, with surveyors, they may probably forget that they are lawyers first and foremost, because they are doing part of the work, or accountants are influencing them or whatever. So I think that is part of it. Our laws, most of the laws are obsolete. This also impacts on our discipline. Then the discipline process itself is a bit cumbersome and sometimes takes years. I will quickly go to what I call recommendations. 1, we should hold the observance of the rules of professional ethics very, very sacrosanct. I always tell people, a lawyer without integrity is not worthy his call. Because that is what the society invests in us. Our integrity, our honesty. People should be able to hold you to your words. Lawyers should be able to be consistent. You don't argue one point in this court and run to another court to argue the opposite of what you have argued before. I don't think it is right. I believe it's not right. Because you must be consistent. So I think it's quite important. Then we should sanitize the legal space. Ensure that non-lawyers are weeded out from our practice. And that reminds me about the debate about stamp and so on. What people seem to forget, one of the reasons for the stamp and seal thing is this scourge of so-called fake lawyers. And those who were in Breakout in 1982, the crisis started because there was allegation that non-lawyers came to that conference to vote. So we must get to a point where we are able to let people know, once you say you are a lawyer in Nigeria, people should know you are a lawyer. Then we have to amend the RPC to ensure that people who are not advocates, as it is now, it's as if only lawyers who go to court are the people who must observe rules of ethics. We forget company secretaries, legal advisors to corporations, law teachers. And there is this argument that I had before that, oh, if you are, and somebody was even propounding it there, that those of us who work for government, we have civil service rules. Voluntary, non-fit, injuria. you are a legal advisor, you work in the Ministry of Justice, because you are a lawyer ab initio. Otherwise, so you must still be subjected to the rules of ethics. So that's very important. You can't say because it's not double jeopardy, it's not at all. It's just that you have a duty to the profession on whose platform you get engaged at all. Otherwise, they won't engage an engineer to come to the Ministry of Justice to prosecute cases. You are appointed because you are a lawyer. So you are answerable to the profession for whatever you do. So we must ensure that other people who do legal work other than advocacy are also made answerable for professional misconduct. And I also made the point that those who have been sanctioned by LPDC should there will be maximum publicity so that people will know. I made a point here that the new LPDC was constituted sometime in March 2013. And to my knowledge, as I'm speaking here, I think that the LPDC currently, we are at the bar, and I'm a privileged member of that body. We've written directions in which 15 lawyers had been debarred. 3 others were suspended for various periods from 2 to 5 years. But everything is not about debarring people. We've had to discharge 17 of our colleagues when cases were not made against them. And to make the prosecution to be up and doing, we also struck out about 15 cases when they were not ready to proceed because they had no witnesses to prosecute the matters. To let you know the extent of the problems we have, in spite of the fact that we all know not all cases of complaints ever get investigated. We still have all these sentiments at the branches and everywhere. Oh, it won't be from my hand that his own will be destroyed. I won't do anything about it. We sweep some of these things under the carpet. I have canvassed in this paper that sweeping of complaints of misconduct under the carpet should attract the same sanction, because it's not a screen of an offender in criminal law. So it should attract the same punishment like the person who should have been reported, so that people will be up and doing. In 2013, when this new LPDC came, we inherited 37 matters. In that same year, 16 new ones were filed. In 2014, 13 new ones were filed. And as I'm talking to you, as at the last time we sat, I think in June, we have 17 new matters pending. We could have cleared some of these matters, but it's a matter most of you will have been aware of. The Supreme Court came out with 2 judgments which virtually nullified the LPDC because the Supreme Court formed the impression, Akin Jogbin and Akin Kotu, that, oh yes, the Decree 21, which actually established the LPDC and made appeal direct to the Supreme Court, was not part of the laws combined in the 2004 laws of the Federation. And the Supreme Court had the impression that once it was not in that compilation, then they were not extant laws. Happily, whether rightly or wrongly, the Attorney General had done a supplementary laws of the Federation in which this decree, which is now an act, has been incorporated. And that is why the LPD, otherwise, for about 6 months, we were not sitting at all because of the confusion. Because if we had sat, actually...
They say, time up.
Thank you. So technically, just this last point, Madam Chair, if we had been sitting, one, we won't have the locus to sit because it is under that decree that the LPDC was set up with the membership it has now. The old one in the Legal Practitioners Act had the Attorney General of the Federation as chairman of the LPDC. And that was also nullified in MBA against Ganifa Wemi. 2, if you had constituent sitting, there will be no place to appeal to because the appeal committee of the body of benchers had been abolished. Thank you very much, Madam Chair. Thank you, my colleagues.
Permit me to call on Odeyin Ajimogobia SAN. 8 minutes.
The chairperson, my lords, distinguished colleagues. I want to thank the chairman for her summary, which I think makes all our tasks a little simpler in highlighting the essence of our rules of professional conduct. Let me begin by saying that I think there's a mismatch between the public's views of our profession and our own perception of ourselves. This is not new. And if you go to legal websites, there are a lot of literature in forms of jokes and caricatures about lawyers. And these you'll find are probably divided into two sets of ideas. One, the character of the lawyer. You hear it said commonly that lawyers are liars, and we laugh about it. People say that lawyers turn black into white and white into black. That's the public perception of the lawyer. Of course, because we in the profession practice it, we dismiss these notions as misconceptions. The other is the role of the lawyer. And I think that the role that we play especially in the adversary system, is promoted by the adversary system of justice, where two sides against each other and the truth emerges through a process of a contest between the two sides. I think we must accept that there's a gap between our professional ideals as stated in our rules of professional conduct and the practice. And I think what's of concern for us at this time in the life of our profession, and why this topic is particularly important, is that this gap is widening. What are the ideals? The ideals were amply stated by our chairman. They're found in our rules of professional conduct. How far have we maintained those rules? Someone said that in the previous session, I think someone said, there are very few people in the profession probably who have the rules of professional conduct at their fingertips. And if we look through those rules, and I did in the course of preparing to speak at this, that there are many rules that I wasn't aware of or I'd forgotten. I think we urge all of us to go through those rules. What are the reasons for the widening gap between our ideal and our practice? I think first and foremost is poor education. The educational standards have dropped. The training of lawyers is not at the same standards as it used to be, and I think that's the starting point. Ethics are not taught with the same rigor as they used to be. I think there's also a dearth of role models, senior lawyers who we could look up to. When I was called to the bar, there were many lawyers. There weren't as many of us as there are today. I hear there are 4,000 lawyers being churned out of the law school every year. My class at the law school was probably 400. And so, as the chairman said, we knew each other in court. If you knew who was your senior, you knew who was your junior. That's more difficult now. But role models in showing how it should be done, the decorum in the courtroom. We've seen senior lawyers now having almost fisticuffs outside court over a client's matter. If you read the rules of professional conduct, you can't do that. Etiquette and moral good practice. That's always the dilemma, because as lawyers we're trained to focus on what's legal, not necessarily what's right. But our rules of professional ethics try and put in some morality in terms of what we're expected to do. I think another factor that's helped drive this gap between our ideal and the practice is the number of lawyers, competition. There's so many of us, there is limited work, and so we're competing with each other, and that has created a lowering of standards, because one of the rules of professional conduct, for example, is you shouldn't charge excessive fees. It also says you shouldn't charge low fees. Your fees should not be so low. But many people in the profession will charge anything just to get the work, and that creates a falling of standards as well, because if you're not paid properly, you probably don't apply yourself to the same degree. I think perhaps going back to one of the previous sessions where Reverend Father George, I can't remember his last name, but gave a very, very educative paper which was being circulated. And he talked about justice, the notion of justice, regardless of how you describe it, but the justice of truth and diligent diligence, the essence of it is basically truth. I think we've moved in many ways, most societies, and not just Nigeria, has moved from law as a vocation to law as a business in many areas of the law. That's not to say that all areas of the law do that, but there are many areas of law where the law is practiced as a business. Law firms are run as businesses. They have costs and they have to run in that way. And I think that transition from law, from the vocation to the profession, to the business, has influenced the lowering of professional standards to some extent. I come to money and justice. When I talk about law as a business, of course, it's money. The rules of professional conduct devote a significant space to fees and remuneration of lawyers and what you should and what you shouldn't do. And it's for that same reason. We tend to serve our clients' short-term interest at the expense of the other values that are highlighted in our rules. Undivided fidelity to clients' interests as opposed to the public order or public duty. I think this creates a tension. There's a tension between the private codes of conduct to deal with this. I think the rules, to some extent, are a bit abstract. I think perhaps, again, supplemental codes can be drawn up to draw attention to specific conduct that's not permissible, so that it can be monitored and dealt with. Going back to the issue of access to justice, I think this was a suggestion made, and I think it's a good one, that we all should be involved in public duty of pro bono work. I think every lawyer should do a certain amount of pro bono work. That's the only way that we can promote access to justice. Justice has a cost, it's a fact. It costs, the infrastructure of the courts cost money, maintaining the processes cost money. And if you're going to have access, universal access to justice, somebody's got to bear the cost. And I think we as a profession should take it upon ourselves to bear part of that cost. I think I will...
Please, round up.
Yes, just briefly, one of the things that I think has really put the profession in disrepute is our contribution to the issue of delay in our courts. And there's, again, I talked about the tension between our duty to our client. We want to do what our client wants, but there's a duty to the public. The case of Associated Discount House versus Amalgamated Trustees, I think highlights, and Mr. Chairman, if I may, just highlights the point I want to make. In that case, the plaintiff sued in the Federal High Court to recover a loan. The defendant objected, said the court had no... So it went up to the Supreme Court. This took 7 years. They hadn't gone into the merits of the case. And I think this illustrates the role that we play as legal practitioners and some of the things we do that really do not serve the purposes of justice. Thank you very much.
Thank you very much. Mr. Lamikon. 8 minutes. I won't be lenient.
Madam Chairman, Chairperson, my lords, learned colleagues, good afternoon. The last speaker touched on what I wish to focus on in his very closing remarks, and that is delay. Delay in the administration of justice as it relates to the question of misconduct. Now, it is insidious, but it is actually a real threat to our profession. Lawyers are officers in the temple of justice. And we have heard it said many times that delay defeats justice. So we would have thought that if anyone should avoid delay in the dispensation of justice, it surely cannot and should not be lawyers. I believe that the single most substantial reason for delay in cases before our courts is us lawyers. And it's time, I think, we tell ourselves some home truth. The topic of this session is uplifting ethical standards. It is time, I think, to speak to ourselves as colleagues, as friends, as people who share a common profession, a fraternity. If we do not begin to deal with this aspect of our practice, there is a real threat that our profession could go into extinction. Because the very service that we profess, the profession that we have embraced, is in jeopardy of becoming irrelevant because of delays. I wish to just draw attention to those aspects of the rules of professional conduct that would assist us. I won't read them, I will just highlight them so that we get a clearer grasp. Because when you talk about misconduct, we think of them in the more serious, more vociferous aspect of it that leads to disbarments and disciplinary proceedings. But delay actually is one that I believe is a first offense. Rule 14, and in particular sub-rule 2E. Rule 14, sub-rule 4. Rule 14, sub-rule 5. Now, I cannot for time constraint go into what these rules say, but some of them talk about negligence. Some of them talk about personal presence in court to present cases on behalf of your client. Negligence can sound in processes that ought to have been filed within a particular time. Oh, you feel that you can always come with extension of time, therefore you fail to file within time for no particular reason other than indolence. Should that be construed to be misconduct? In certain circumstances, yes. We all know that, for example, practice at the appellate court. If you fail to file your brief within time, for example, and you come with an extension of time to file your brief, in most circumstances, in my personal experience, the application for time extension or any application at all at the Court of Appeal level could last anything between 9 months to more than a year. Whereas, if the rules are followed strictly, we would see that if you file briefs within time, no judge, no court would have any reason not to hear your matter, because there would have been no reason to have any application pending. Rule 15, sub 3. That is particularly important. It says you should not accept any brief if the whole purpose of acceptance of the brief is to occasion delay. Why would you do that? If a case is hopeless, tell your client your case is hopeless. If there are some other ways to deal with the matter, for instance, alternative dispute resolution, why shouldn't you point your client in that direction? Why should you accept that brief, knowing that the case is hopeless? Like the associated distant houses that has just been cited to us. Rule 15, sub 3, D, C, especially. Rule 16, sub 1, A and B, emphasize incompetence. You are briefed in a matter or on an aspect of law that you are not really well grounded in. You didn't send that client away to some other colleague who is probably much more experienced in that area. You did not call assistance of a colleague to come with you and handle that matter together. you know you are not really grounded in that area, but you accept the brief. And what do you do after accepting the brief? You fumble, you forge, you delay. I think these are conducts bordering on the infamous as far as this profession is concerned. Rule 30 is what we all know so well.
A lawyer, you have a minute and a half.
Thank you, ma'am. A lawyer is an officer of the court. And if you are an officer of the court, your first duty is to the court and not to your client. So in summary, delay in the administration of justice, especially where a lawyer is involved, knowingly or unknowingly, assisting in occasioning delay to speedy dispensation of justice, I would posit that it borders on misconduct. What is the solution? There are tools in the hands of our judges, tools including costs being imposed on the lawyer rather than on the client, and many other tools, which I think the rules of court for the time being need to be reviewed to see how we, the lawyers, could be made to take more responsibility for cases that we initiate or that we defend. Thank you very much.
Thank you very much. Well done. You're not SAN for nothing. The next speaker is Anga. Please. 8 minutes. Thank you.
Madam Chairman, my lords, my learned friends of the inner and outer bars, distinguished ladies and gentlemen. And if you don't belong to any of those categories, I'm not sure you should be here. Raising the bar, that's what we're talking about. How do we raise the bar? There's no point going into what the rules are and all that. So I just want to make one or two comments. Now, when you talk about ethics, ethics generally, the definition of ethics divided basically into two. You can be talking about norms, values, characteristics, the moral compass of an individual or a group. Or, which is more relevant in the context that we're speaking today, you talk about ethics in the sense of standards, a standard of conduct, particularly a professional body, a church, or whatever, okay? So what might be unethical professionally may not necessarily be morally wrong. So if you say, for example, it's unethical for a lawyer to advertise, someone in another profession may find that advertising is ethical. In fact, indeed, within different jurisdictions, the question of advertising, as you know, is a subject for debate. But what I think we should emphasize on here is those standards, those rules of professional conduct. Now, Rule 1 of our rules of professional conduct requires lawyers to uphold and observe the rule of law, promote and foster the course of justice, and a high standard of professional conduct. And lawyers shall not engage in any conduct which is unbecoming. Conduct unbecoming, high standards of professional conduct, promotion and fostering the cause of justice. That is the calling, and that is the purpose of the rules. Now, I'll tell a story very quickly. At the Hilton, somebody told me this yesterday when I said I was coming here to speak. He said, Fubara, let me give you a gist. I said, which gist? He said, a few years ago, he was at the Hilton standing in the queue to buy a ticket to come back to Lagos from Abuja. And this gentleman walks up, well, not robed, but at least wearing his lawyers with his bib and everything. And he walks past the long queue and goes to the front, writes his name on a piece of paper, and gives somebody some money so that they could. And so this friend of mine says, people were murmuring and objecting. He was incensed. And so when this gentleman came back, he said to him, he said, but come on, that's not right. I mean, you shouldn't do this. And the guy says, what do you mean? Who are you? Why are you asking me these questions? And he said, I'm a lawyer. He said, you're a lawyer. He said, when were you called? The guy said, about 33 years ago. He said, 33. Okay, I'm an SAN. Okay. You're an SAN? Yeah, in fact, I'm a former Attorney General. Now, the question is, how many rules of professional conduct have been breached? Of course, I forgot. The last point was he almost came to blows because he said that the chap was embarrassing him. In the first place, he shouldn't be going up and down with his babe. Once you leave court, you take it off. How many lawyers have the collars? You see our lawyers on Okada with their babes. Conduct unbecoming. And don't use the excuse of poverty. No. And I dare say, every bar association should ensure that there's a robing room in the courts, for goodness sake. Now, when you talk about rules of professional conduct, you see, we still operate this quasi-criminal, disciplinary enforcement mentality to ethics in the profession. By the second definition, it's clear that that is the promotion of standards. It's clear that ethics, nobody is born ethical, okay? You are not born ethical. You have to be taught. If you are not taught, you cannot know. Till tomorrow, you still see people who put their surnames before their first names. And I keep on, it drives me nuts. First name means first. Middle name means middle. Last name means last. But someone will say, what's your name? Say, Anga Fubara. Tomorrow is Anga Lawrence Fubara. Next tomorrow is Fubara Lawrence Anga. Till tomorrow, I don't know if Atiku is his first name or Abubakar. And until we had GEJ, sometimes you will think that Jonathan was the first name and Goodluck is the surname. And that's what I'm talking about. There has to be a consistent standard. What are the recommendations? I've looked at a few other jurisdictions, Commonwealth jurisdictions. And one thing that has happened is to separate the notion of advocacy, the NBA, the Law Society, from that of discipline. And so they have, in many of those instances, created an independent judicial body, the Solicitors Disciplinary Tribunal, or for example, in Australia, you have disciplinary tribunals that deal with especially egregious cases. In Australia, what they have are two bodies. One that deals with the question of professional conduct of a lower scale, professional misconduct of a lower scale, and then the tribunal which deals with professional misconduct. In the UK, they've moved to a question of a test-based system. Before you are reported to the Solicitors Disciplinary Tribunal.
Time up.
Well, I will conclude by saying education, education, education.
Thank you. Thank you very much. In the UK, they do something else. That's all. Patrick, please. 8 minutes.
The chairperson of this session, my lords, the senior advocates present, my learned friends, gentlemen of the press. It is very thoughtful of the leadership of the Nigerian Bar Association, ably led by Augustine Alege SN, to have included the topic, how to deal with issues of increase in cases of professional misconduct in this 55th General Conference. The love of the profession is what has brought all of us out of the comfort of our respective law, like nature aims at perfection. So also should the legal profession. It should have inbuilt mechanisms that propel it to the desired perfection admirable to all and sundry. Law is commonly said to be an instrument for development. It aims at an all-round development of the society. It thus follows that practitioners of law must be guided by that lofty ideal. Members of the
noble legal profession must ensure that those who cannot fit into this stream of achieving set objectives are shoved aside so that clients and members of the larger society will accord the profession and its practitioners the age-long awe and respect. The lawyer means different things to different persons. To some persons, I quote, the lawyer is a gentleman who secures your estate from your enemies and keeps it to himself. It is this negative description of the lawyer that has made the making of rules for professional conduct inevitable. The author of the book, The Legal Profession in Nigeria, 1865 to 1962, Omoni Adewoye at page 113, described a lawyer in these words. In almost every society, there's some ambivalence in the popular attitude towards lawyers. Lawyers are greatly valued as practical men of affairs whose talents and special training are almost indispensable in any human organization. Yet, at the same time, people sneer at them as tricksters and quibblers. They are called upon for advice and guidance in the numerous questions, public and domestic. Yet, in private, they are often regarded as equivocators, artists in double dealing, masters, and unscrupulous race of men. This is not to exploit the origins of this unfavorable image of the lawyer down the centuries. The point of interest here is that practice of the legal profession in Nigeria in the period of our studies supplies evidence to lend some color to the image. This is not to deny that there are lawyers with high standard of professional ethics. To avoid these negative criticisms of the legal profession, the Rules of Professional Conduct for Lawyers 2007 was enacted. It is part of the conference text made available to all present. It is also one of the courses taught at our law school and some universities. The provisions of the Legal Professional Conduct for Legal Practitioners 2007 says that our faith and advise all to obey without question and hesitation. What was that to be actually the case, then there would have been no need for this gathering at this hour. There would equally have been no need for the numerous cases pending against some members at the various zonal disciplinary committees. It is very disheartening to note that due to the deluge of petitions against some members of the profession, zonal disciplinary committees were constituted on the 18th of December 2012, with Lagos having 2 panels and Abuja, North Central, Southeast, South-South, and Southwest having a panel respectively. It is imperative for us to keep ourselves well acquainted with the provisions of the 2007 rules. There is no doubt that its contents are quite clear and unambiguous. It is what the multiplication table is to a student of mathematics. One can only ignore it at its own peril. Rule 55, sub-rules 1 and 2 of the Rules of Professional Conduct 2007 states, if the lawyer acts in contravention of any of the rules in these rules or fail to perform any of the duties imposed by the rules, he shall be guilty of professional misconduct and liable to punishment as provided in the Legal Practitioners Act 1975.
2 more minutes, please.
2, it is the duty of every lawyer to report a breach of any of these rules that comes to his knowledge to the appropriate authorities for necessary disciplinary action. I go on to my views on how to avoid and cure defects arising. In looking forward to a better and brighter tomorrow for the legal profession, while adopting other well-meaning suggestions in this regard, it is my humble submission that 1, implementation of the rules of professional conduct must be straightened and not whittled down by any adjudicating or investigative body or tribunal. 2, there must be continuing education of members on the need to adhere to all rules of professional conduct at all times. 3, rules of professional conduct must be reviewed from time to time to meet new challenges presented by the passage of time. 4, law faculties of the universities offering law as a course must be encouraged to teach professional ethics as a course, so also the Nigerian Law School. 5, practitioners that appropriate their clients' funds must be made to face criminal prosecution in deserving cases. 6, the importance of ethics and rules of professional conduct must be a constant at all celebrations of Law Week in all branches of the Nigerian Bar Association. In conclusion, may I crave your indulgence to refer to the observations of Okewale SAN, former president of Nigerian Bar Association, in his 2014 lecture on professional ethics and the future of the legal profession in Nigeria, where he stated entirely, quote, "No doubt professional ethics is a key component for the regulation of lawyers. The NBA is committed to the enthronement of the highest standards of ethics among members of the legal profession. It is not only a job for the NBA. The impetus for change is coming from all sources: the public who bears the brunt of ethical conduct, the profession concerned about its image, and the government that previously felt unconcerned about ethical practices, seem united in their condemnation of ethical lapses among lapses."
Time up, time up.
Well, I thank you all, and I hope that the organizers of this conference will make our speech available. Thank you. God bless you.
Thank you very much. Alex, you know what I'll do to you if you overspend your time. Okay.
Good evening, Madam Chairperson. My task is very easy. I'm basically to share with you what the NBA Lagos branch has done in dealing with cases of misconduct. And I'll go straight to the point. Now, let me start by entering a caveat. The topic assumes that the NBA Lagos branch has been very successful in dealing with cases of misconduct. That is not correct. I can assure you that the experience of the NBA Lagos branch in dealing with cases of misconduct is no different from other branches. It's a work in progress. What is true is that we have striven over the years to enthrone excellence in our approach to legal practice and the upliftment of ethical standards in the legal profession. I'll therefore share with you what we have tried to do. But let me warn, the lessons I'm going to be sharing with you are by no means just the ideas and programs of the branch. No, we have things that the branch has done as a branch. More importantly, we have things that members of the branch have done in their individual capacities. Now, primarily, our approach at the branch has been to seek to change the attitude and mentality of our members by directing them towards a minimum standard of ethical behavior. We adopted the following measures. Education and enlightenment. The branch emphasizes the enlightenment of our members on issues of ethical behavior and proper conduct. On our own, and in partnership with some bodies, we have organized lectures on professional ethics and proper conduct. For instance, in July 2014, as branch chairman, I delivered a paper on professional ethics and orientation, any relevance outside law, at a conference on delay in justice administration organized by the Lagos State Ministry of Justice. We've invited eminent senior members to speak to our members at our monthly branch meetings on issues of ethics and professional conduct. We have discussed a partnership with a service provider to erect pictorial representations of proper dress etiquette for lawyers in court at our meetings. Letters of good standing. Now, one of the things that we have to do as a branch is issue letters of good standing to members who request that for various purposes. Now, the Lagos branch will not issue a letter of good standing to a member who has been sanctioned for misconduct. In addition, we will not issue an unqualified letter of good standing to a member who is presently facing a disciplinary complaint issue. Mentoring. The Lagos branch has a reputation for producing outstanding lawyers who are renowned for their high moral rectitude. Examples, of course, include the chair of this session, Mrs. Hairat Balogun Owen, Life Bencher, the late Chief Kende Shofola, QC, SCN, MON, CON, Patunji Gomez, a matter of conscience, just to mention a few. Now, these distinguished persons serve as role models and mentors for the younger crop of upcoming lawyers. We also regularly honor deserving senior members in order to hold them up as an example for younger ones. Now, on an individual basis, we have senior lawyers and law firms who are members who have instituted mentoring programs for younger lawyers and law students. Some firms have instituted a program where they invite groups of law students into their offices for a day with this principal partner. Bar meetings. The NBA Lagos branch emphasizes a rather strict dress etiquette for our general meetings. Men must be attired in conservative business or formal suits with sober ties, preferably as suitable for appearing at pretrial conferences in the High Court or before the Magistrate Court. Ladies must be attired in formal suits or dresses similarly suitable for appearance at pretrial conference or at the Magistrate Court. Now, the chairman presiding at the meeting will refuse a right of audience to a member who is not properly attired. We've had instances, for example, where very senior lawyers have rushed into our meetings straight out of court and have not had the opportunity to change their dress. So they come in wearing their court attire. Now, generally, they would apologize for their dress, their wrong dress, and seek permission before they can be allowed to address the court in that, the meeting in that attire. Now, the idea is not to punish people. No, it's to emphasize the fact that a meeting of the bar must look like a meeting of the bar. Bar dinners. Now, everybody knows that the Lagos branch, we're renowned for the bar dinners we organize. We hold 2 formal dinners every year. We hold a dinner sometime between June and July during the course of our annual law week. Now, the dress code is formal. By formal, we mean lounge suits, full lounge suits, business suits, or dresses. We do allow complete traditional attire. That's for the bar dinner in July. We hold a strictly black tie bar dinner at the end of the year in December. And when I say black tie, I mean black tie. Men must turn up in black suits, preferably tuxedos or dinner suits, white shirts, black bow tie or black long tie. Women must come in formal black dinner wear. Now, the idea is not to enshrine an elitist practice. It's meant to remind us that we are lawyers. And when we dine, we should dine as lawyers. When you make people dress up for an occasion, the principle is that as they dress up, they are also putting on their good behavior. Now, I should say that when we introduced the idea of a strictly black tie dinner about 4 years ago, we did meet with some resistance from members, but we were able to surmount all that. Now, despite our best efforts, members insist on infracting the rules. What do? Like when we have complaints about misconduct, we strive to mediate first and see if we can resolve it. If we cannot, we escalate it to the NBA National for handling and disciplinary committee. We also prosecute fake lawyers. Now, what more can be done? Very quickly, I think there's a lot that can be done at the branch level, at the individual level, and at the national level. Leadership. At the individual level, we need our senior lawyers to show good leadership. And of course, examples have been given by the chairman of the occasion in terms of pointing out wrong dress or wrong behavior by lawyers in courts. Now, at the branch level, we need more structures to strengthen the branch and education and enlightenment programs. And I would recommend that to all the branches. Now, for the NBA National, I want to make some suggestions. Now, the NBA has a significant role to play. One, the NBA does need to ensure that the NBA constitution requires that every lawyer should belong to a branch. One of the things we find is that we have complaints about lawyers, and when we check our books, they're not members of our branch. We have a number of lawyers who are not members of any branch. Therefore, the branch cannot even begin to intercede in cases of misconduct. Secondly, the branches need to be strengthened and given more disciplinary power. The present disciplinary process in the NBA does not give the branches coercive disciplinary powers, so money should be done in that direction. Finally, I want to recommend that the NBA National should set a good example. One, the NBA National should set minimum standards of dress etiquette for lawyers. Law is a serious business and we should take it seriously.
Time up.
I would like to end there. The final conclusion was that the NBA should have a black tie dinner as part of our annual general conference. Thank you.
Thank you very much. Thank you very much. If you overspend your time, that's indiscipline. Distinguished speakers, my learned friends, you have heard from the speakers. Now follows the interaction for how many minutes, Dilly? Interaction.
15 minutes.
15 minutes. Dele is going to be in charge. The battle axe will just watch. Meanwhile, I will just summarize the salient points that everybody has made. Conclusions: hold rules of ethics as sacrosanct. Call for review, that is supplementary codes of discipline. What role for the Nigerian Law School? It suggested that they get into the act, as well as the universities. They must teach ethics. We can ask the NBA to pay attention to rules, teach us how to charge. Delay defeats justice. We must be careful that this does not lead to a charge of indiscipline. Advocates, somebody is advocating that two bodies may be formed to regulate discipline. Continue education in ethics especially, and dress appropriately. So please, unless you have further suggestions and you want to make more points on that to get the points home to the organizers, the floor is yours.
I think we should give a round of applause to our chairperson. Of all the sessions we've had at this conference, this has been the most timely, and I think she's an accurate timekeeper. Please, for those of us that want to seek clarifications or ask any of the speakers questions, so you can raise your hand. Kogito, I hope we have the microphone. Where are the ushers to the microphone, please? Please, you're getting the microphones there. Please, Kogito, didn't tell me, you can assist us, please. Come this way. Please, for purpose of asking, just mention your name and maybe your branch before your question, please. And you can also specifically ask general questions or direct at any of the speakers, sir.
Madam Chair, distinguished speakers, my name is Adegboyega Womolo. Let me thank all of you for your thoughtful sharing. The problem of the NBA or legal profession for now, particularly practitioners, is that we don't seem to realize or accept that these words have meaning to legal practitioners. The word honor, the word dignity, the word honesty, the word integrity. These four words are what we would describe a lawyer as. And with respect, it looks like the senior advocates were the most guilty of this misbehavior. I am a senior advocate, and I see a lot of my colleagues, when they do things, I mean, it makes me unhappy. A senior advocate took a brief from somebody who says is a trustee of an incorporated body. He had no other proof other than the man walked to his office and said, I'm a member of trustee. He took a brief, they paid money, they shared money. Other than seeing the man in his office, he had no other instruction. And when I said, the man you are dealt with was never a trustee, that's an embarrassment. It is only until recently that we see that our colleagues who come out of court in their wig and gown, addressing television, trying to pontificate to the whole world what was uncompleted or what was not finished or what was partly done in the courtrooms. I know that the body of benchers took very serious exception to this practice. But I believe that we need to reintroduce mentoring. And mentoring means that you must be above board before anybody else can copy you. At the moment, a lot of juniors accuse me of headmaster. You see the way they wear their wigs. You know, some will be looking this direction, and looking this direction. Some of them would put bib on dinner shirts. We need to begin mentoring again as a way of bringing back the best of the legal profession. And as I said, I want to commend the LPDC for how far they've gone in trying to enforce punishment for misbehaviors. But that is not enough. What we need to do is to try and continue to educate one another from time to time. It's only at annual conference we talk about ethics, ethics, ethics. Why not make an ethical issue or an ethical something a monthly program by NBA National all over the country? Apart from the meeting of the branches, let's have national organizing meeting on professional ethics as a way of education and retraining of ourselves. Thank you, Mr. Chair.
Thank you very much, sir. Please, let your contribution be about 1 minute, please. Yes. There's a young lady here, please.
All protocols duly observed. My name is Ayo Dele Oyedepo. I'm from Ilorin branch. I think my question would have been more appropriate at the session on rights and privileges or obligations of lawyers in salaried employment. But since we are talking about the rules of professional conduct, I think I can still hear it here. My question is about, because recently the judiciary are evolving ways of enhancing adequate service delivery, particularly for the judges. They've now designed systems whereby research assistants are assigned to the judges. These assistants help the judges in researching cases and for them to deliver their judgment appropriately. Now, how do we classify these researchers? Are they part of the bar? Obviously, they are not judicial officers. The bar will be saying, pay your practicing fee, whereas there is no corresponding privileges coming from the bar to them. They are just floating between the bar and the bench. Please address this. Thank you.
Thank you. Yes, sir.
Okay. HS Greatness Agadaigo from Delta State. I just want to speak on what Mr. Ajumogobi has said, SAM, that when he was talking about there's a gap between professional ideals and the practice, he went further to say that he believes that running law as a business instead of a vocation has reduced the standard of the profession. And I want to sharply disagree with him. Because even in a young lawyers meeting yesterday, when they talked about the evolving new trends of legal practice, they said that it is now necessary for us to run legal practice as a business in a more business-like manner, because it makes it more professional, it makes it more competent. So I do not subscribe to running it as a business lowers the standard, because it will even make it more ethical, because you know if it is when you do the needful that you are bound to attract more patronage, since we are not a profession that does advertisement. So that is my point, that we need to run law as a business.
The point you say you attract more clients, not patronage, so that you don't...
Yes, it attracts more patronage because you you produce better
I'm
results.
sure you already seen the implication of running as a business now. It's affecting the way you make your point. So, that gentleman is, look, yes. The one behind you, sir. Yes.
My name is Nabulu Barry Naziga Lue. I'm from Port Harcourt branch. Flowing from what the learned SCN had just said, my question is,
which of the senior advocates, sir?
Okay, the senior advocate that responded first.
Okay, Yusuf Ali SN.
Yes. Okay. Why is it that the Legal Practitioners Disciplinary Committee had not found it worthwhile to discipline senior advocates that are found wanting in conducts that are unprofessional, other than waiting for petitions that may not emanate from juniors or emanate from their fellow silk to say we will assume jurisdiction over such matters and discipline the senior lawyers that have been found wanting? Secondly, why is it that the Legal Privileges Committee had not also found it worthwhile to withdraw such privileges from very senior lawyers that have been found wanting in these respects? That's my humble question.
Okay, thank you. I think we'll take one more before we ask the specific. Yes, sir. Yes, sir.
The chairperson of the session, learned senior advocates, all other protocols observed. My name is Cyril Ogbekene. I'm of the Banawa branch. I just want to share my thoughts on the topic. I believe that uplifting the standard as placed before us as a topic goes beyond upholding the standard. And I think everybody's touched on it. Uplifting the standard certainly goes beyond just upholding what we have in the written ethics. And several classes of conduct that are not necessarily codified is what the conference expects us to take away from here. Wherever we go, we should remember first and foremost that we're lawyers, and that people expect something beyond the ordinary from us. It's like in religion. It is those who are not Christians that will first say to you, and you call yourself a Christian. Let us avoid situations where people will say to us, and you call yourself a lawyer. Thank you very much.
Thank you very much. Yes, the gentleman on that far right. That should be our last question.
Chairperson, learned seniors here present. Uplifting at my name is Abdul Malik Jafar Suleiman from Kaduna branch.
I didn't hear you, sir.
Abdul Malik Jafar Suleiman from Kaduna branch.
Okay, sir.
So uplifting the ethical standard, I believe it has to do with beyond our relationships as lawyers and the way we conduct ourselves, but also how we portray ourselves to the society. There is this practice that is very, very unethical, where senior lawyers have turned junior lawyers to their drivers, where they keep sending junior lawyers to eateries to buy food, to banks all the time, and to also some of their domestic activities. Secondly, sir, there are some lawyers that are fond of furnishing all the cars in their houses and those of their friends with the NBA stickers, because they feel as lawyers, all the members of their families are lawyers. And at the end of the day, the privileges we get with those stickers on our cars tends to be gradually abused or withering away. The policeman will see you driving recklessly, see this lawyer. Traffic wardens, see this lawyer. Unknown to them, they are known lawyers. So I think this issue should be addressed seriously. Thank you.
Thank you, Madam Chair, sir. Okay, I should proceed. I wanted to direct. Yes.
The speakers will now like to respond.
Okay, sir.
Two of them.
Yes, there was a question specifically directed at Leonard Sikh Odein Ajimogobia, that on the issue of how to relate whether the law is business or is a vocation, that they were only taught just yesterday that they are now businessmen, and they are now tending to go back to being lawyers. So I don't know what you want to say to that, sir.
I think I was slightly misunderstood. I don't know how many of you watched the movie Wall Street many years ago, and Michael Douglas, who was the main character, said, he was talking about capitalism and business, and said greed is good. You know, the point I was making is that as opposed to care and compassion, which the vocation focuses on, when law is converted to a business, the focus is on the monetary and making money. So you become a businessman and your focus is on making money and not focusing on your duty to the public. That's the point I was trying to make.
The question about researchers or legal assistants to judges. That innovation serves a lot of purposes. One, it's an opportunity of employment for some of our colleagues who get appointed as legal assistants to judges. And it's not an innovation in this country. We borrowed it from other places. In the US, it's a normal thing that the judges and their justices have legal assistants. And some of them rise from there to become great judges too. Number two, if you're a legal assistant, you are still a lawyer. You are just in paid employment. It's like being employed as a registrar in the court. Only that your function is different from that of the registrars. So they are not just hanging there. You may choose, and I see that in future, we may develop to a level that people may choose it as a career path in their own career advancement in life. Now, LPDC and senior lawyers, I think my learned friend from Port Harcourt had not been following the events closely. Now, we must remember at all times the tenets of the rule of law. Your proposition is like asking that a judge who witnesses an accident could just proceed from there and sentence the driver that is involved without any formal complaint before him. The LPDC is a tribunal. That's the real name of it. Actually, it's a professional tribunal that tries colleagues or erring colleagues for promotional misconduct. So you don't expect them on their own to initiate, because that would be totally against the rules of natural justice. Both alterem patem and nemo judex in causa sua. And please, you can go and read the case of FRME against NBA. If you check any of the 1985 series of Nigerian Weekly Law Report, you'll find 1 and 2. You'll find them there. Lawyers, as lawyers, we must be very careful, even in our eagerness to sanitize the profession. We should not make the rule of law become a victim. The LPDC will have to rely on what is in the law. The law says for the jurisdiction of the LPDC to be activated, there must be a complaint brought by the Nigerian Bar Association after a thorough investigation, and that a prima facie case of misconduct had been established against a colleague. It is at that point the matter comes to the LPDC. May the day never come when the LPDC will just say somebody has announced something somewhere, and then LPDC goes after the person. You don't know when such a behavior may become too capricious, that people go after their enemies, quote and unquote. So it's very important. Let's maintain the balance between the rule of law and presumption of innocence and other things. And I can assure you, if you have been following the event, one senior advocate only recently, less than 2 months ago, was actually derobed by the LPDC. So, but I wouldn't want to say much about that because it may become sub judice. LPPC, the Legal Practitioners Privileges Committee, also, if you have been following the events, a former Attorney General who was a senior advocate was suspended for a number of months before. And not quite long ago, another senior advocate was actually suspended pending certain things to happen. So I believe that we should not look at the disciplinary procedure as a game between the high and the mighty, the senior advocates and the non-senior advocates. Anybody who breaches the rules and is properly reported and the procedures for discipline are followed, you can be very sure that there will be no sacred cows as far as the profession is concerned. But let's follow the rules to the letter. Thank you.
I think just to add a little bit of rider on that, I think there was a decision at the NEC meeting in Sokoto that even the issue of Legal Practitioner Privileges Committee discipline members was illegal, and that it should yield to the LPDC to deal with all cases of discipline. That was just a resolution from that NEC meeting, just to update you. I think I will see one, if there's still other comments about senior lawyers turning their juniors to drivers.
Okay, sorry.
Buying of food.
Thank you very much.
Domestic servant and
I think you have to
MBA stickers.
Look at your letter of employment. What is contained there? Or your terms of engagement. But seriously, I think that it shows lack of being busy professionally. I don't think we should turn ourselves into slaves, houseboys, housegirls, and so on and so forth. But of course, we must also realize that we are in Africa. There is, of course, because we must be practical about it. If, for example, I have a son or a son who is a lawyer, is it too much for me to say, okay, take my key, go and do something for me? I think we must also look at it holistically.
I don't think the complaint is a one-off. I think the speaker was complaining about a habitual slave dealer, you know, who looks at his juniors like slaves and just send them up and down. But I think, once again, I always believe anybody who's old enough to qualify as a lawyer has an independent mind, and you can conduct yourself in such a way. You won't give offense, but you will know what to do. Maybe you are supposed to go home at a certain time, and that's the time he says, go and buy me a loaf of bread. All right, sir. I will just go home. Next day, what happened to you? Where's my loaf of bread? Ah, I didn't hear you. What happened? It was, I thought, oh, I'm so sorry, your guy. It won't happen again. He will get the message. By and by, he will get the message. And of course, all the juniors must act the same way. You don't want to do all these menial jobs just for favoritism. You must all act independently, act the same way. So you'll soon get the message, and that's it. And you'll all be senior lawyers one day anyway. So at this time, we're supposed to yield the floor to the section on general practice. We're supposed to yield the floor to the president. Is the president available in the house?
It's not back, but that ceremony will be done tomorrow.
Tomorrow?
Yes, sir.
All right. Well, I think there is no crime in ending on time. And all I have to do now, I have to do this one standing up to thank the speakers for their time. And you assist me to do that by clapping for them. Thank you very much.
Well, we want to thank Madam Chair for actually keeping to the ethics by keeping to time. And I'm sure if we conduct all sessions like this, it has certainly made my job very easy. I thank all of you. And I want to also make by word of general announcement that all papers presented at this conference, before you leave, will be emailed to you. We intend to eventually do a compendium of books on them after proper edition. But we'll definitely email all the papers, please, to you. That is the new way to go. And as you know, from very soon in the Supreme Court, you will be receiving all forms of processes by email. Thank you.
Thank you very much. No clap for Dele, please.
Thank you, sir. Thank you, sir. Thank you, sir. Thank you. Thank you very much. And those of you invited to the dinner, it is 7 p.m. sharp. And our Madam Chair will be there. So I ask you to be there before 7. Please, one of our members lost a book, Practicing Sharia Law. So please, if you see it, please try and return it to the front desk. Thank you. Today is Secretary's Night at the Friendship Center. The General Secretary and all past secretaries will be hosting you this evening from 9 p.m. Yes. So go home and change and come back. At the Friendship Center, please. Thank you. Please, we have found the book. Please, Practicing Sharia Law. The owner should come for it. Please, we have found the book. I think the person who took the book knew the implication. Please, come and take your book, please.